okuthile ngomzakhulelwa njengoba ngangithi umzakhulelwa ngangilandela ukuzaleka kwami mina uqobo ngagcina ngithi ke namhlanje ngizele umzakhulelwa uye yedwa indodana yami ekhona la ekhaya engethembele kuyo ineyingane la igcekeni iganiwe ithemba lami benginalo kutefa ukuthi ngelinye ilanga ingane yami izophuma kuleya ndawo ekuyona ngendlela ebengimbona ekhuluma ngayo nangendlela ebengazi ngayo nami ngoba bengazi ukuthi umzakhulelwa wasiya umbulali kaMeyiwa.
Not far from the Sibiya home is the Ntanzi homestead, the family of the youngest of all the accused. 30-year-old Bongani Ntanzi is also referred to as accused number 2. They tell us he has been the breadwinner of their family, providing for 10 people, including his 9-year-old child. Because Bongani was the sole breadwinner, his absence also meant there was no money to even travel to Gauteng, where he is currently incarcerated. They say he got himself a lawyer, as none of them could afford those legal services. All they could do is watch the trial on television, especially on behalf of their mother, who can't bring herself to watch the proceedings. Every time he enters the dock, she leaves the house to get an update later. It was a shock to them when Advocate Malisela Defo dropped the news of his withdrawal.
Isathatha naye izinto ngendlela yakhe afuna athathe ngayo ukuze egcine bamele kanti bese sithi mhlawumbe sithembile nje emephethelweni for ukuthi ngwanakho usebatholakele ngendlela engibuka ngayo lo mmeli ubesebenzile ngoba kuzovele konke lokhu nje nokuthi abasolwa yilaba abenzi baledwe yilaba kusithemba yena ngendlela besimbone ekhuluma ngakhona nandlela aphenye ngayo kuze egcine sekubuvela ngale ndlela siyambonga yena ummeli lapha khona ngoba konke lokhu nje ade lokhu sikhuthanisa ngene.
In an unexpected but not surprising turn, Defo wrote to the state informing it that he had resolved issues with what he terms relevant stakeholders and will therefore continue representing accused number 1 to 4. But there's a catch. He has listed a number of demands that he wants adhered to before he and his clients can show up in court on Tuesday. Those include a separation of trial between his clients and accused number 5. He also wants a new judge appointed in the matter and the prosecutor, Advocate Maloyi, removed from the case. Defo says he also wants Police Minister Bheki Cele to be removed from his position and be investigated. In the same statement, he reveals a fresh, new reason why he withdrew from the matter. Without substantiating, Defo accused Judge Maumela of witchcraft, citing it as the main reason why he decided to leave the case. Although at the time of this interview these families did not reveal this information, they agreed that he was subjected to unfair treatment in court. Muzikau Khalelwa and Bongani are said to have made confessions, but according to Advocate Malisela Defo, these were obtained under duress. He claimed his clients were severely assaulted through the use of what he called apartheid tactics to get them to confess. He called on the court to hear a special plea for a trial within a trial. His plea fell flat after Judge Maumela ruled that he failed to follow proper court procedure. Defo had also not filed papers as required for a court application, but addressed the court from the bar instead. To top it all, the state had not submitted these alleged confessions to the court or indicated that they would depend on them. The families believe that their children are innocent.
Umfana lo waboshwa konje kwakumhla kabani mama? Mhla ka-30 June. Mhla ka-30 June. Mhla ka-30 May, yes. Waboshwa mhla ka-30 May inyanga yonke singamazi ukuthi ukuphi. Kwazothi ngo June angisazi ukuthi kwakumhla abantu bafika naye la ekhaya ma befika naye la uyangitshela ke ngoba bathi angiye kuye ngiyokhuluma naye uthi baba ngiboshiwe ngendlela ebengishaywa ngayo bengibulawa futhi bengitshela bethi bazongibulala njengomnyu khona bambulala eFosrolas amaphoyisa amdubula bathiwa yiba bambulala nami ke bazongibulala bemvalele ehlathini laba bemvalele khona ngendlela ngagcina ngivuma bethi angivumi ukuthi ngabulala Meyiwa kodwa okokuqala babetha kacindezele laba bazomnikeza 100,000 wathi ngalile baba ngoba ngiyazi into engingayivumela engathi ngizothi laba ngibacindezela ngani ngazini ngangikuphi wathi ke bathi bazongifaka icaleni sebengifakile ke ngigcine ngivuma istatement abangibhalise sona ngizivumile angivumi ngoba ngikwenzile ngivume ngoba ngizikela impilo.
Ntanzi's family also claimed that the same happened to their son.
Wathenjiswa 3 million babemshaya before uthe vumele icala umbhaxa nje ufaka nasefrijini sazi ifriji bafaka ngoba bemfaka belivulile noma babecimile ngazi ke la kude ke khona awuthole lo ukuthi wafaka efrijini
Afake efrijini yabo phejele
noma ngisanoba esejele noma kude khona babembambile bona noma bengamfakile esitokisini kodwa babembambile babembambe khona.
Sibiya's father says he raised the issue at a magistrate's court where he had been appearing for a different matter and was subsequently moved to a different prison. While the state had not submitted these confessions as evidence or indicated that it would rely on them, it has remained tight-lipped on its strategy to nab the accused. The confessions form part of Defoe's representations to the NDPP in a bid to have the matter withdrawn. For some members of the Meyiwa family, these developments were expected. They believe the 5 men standing trial are innocent. They say a plan is on the cards for this docket if the National Prosecuting Authority decides not to prosecute.
Private prosecution.
Oh, so that's your next step, private prosecution.
Private prosecution.
Meyiwa says his brother's case has been at most marred by corruption.
Leading investigator kwa case 375, 635, 636 yantshontsha statement esasodala ukuthi kuboshwe umuntu wayelapha endlini yasitshontsha leso statement ingakho kwavulwa lo case 375 labantu babawu5 baboshela ukuthi kuzanywa ukuthi babefuna yona ukuthi le case ivalwe kuthiwa ifaka sihlamba bukho noma vele sebethenge nama witnesses boshela abafana aba5 ivale ingabe savela leli bashaya phansi ke manje nali selivelile.
On the 26th
phones, I went in for questioning and everything.
Which phones?
Our personal cell phones.
Oh, okay.
Yes, just
they hadn't taken them from you.
They took them from us, and then
the criminals, I mean.
No.
Okay.
They couldn't take my phone because I ran out. I had my phone in my pocket, so they didn't take my phone.
It's where you're at. It's 8 minutes past 4 o'clock. Welcome. It's The Drive with Mo Flavor and Masichaba and Ndlovu. We welcome you to The Drive, Longwe. Thank you so much for responding to our invitation.
I'm actually saddened that my own people can do this to me, you know. I mean, it was a robbery gone wrong, you know. I was even the coward of the day because I actually ran out as those gunmen actually came in and requested phones and money from us. I was actually the first to stand up to try and protect everyone. I wanted to go get help, but it was late. Neighbors and everyone was sleeping. I didn't even have my phone because I left it at the house, so I couldn't call the cops. A fight broke loose inside because obviously Senzo was protecting Kelly because the guys were handling Kelly, and then that's when the guys actually released the gunshot, and then that's when the bullet killed Senzo.
Morning, guys. I hope I get you all well and ready for the case of today. Good morning. Good morning, everyone. Advocate Lebo Umhotsi, good morning. Blessing, good morning. Elvis, good morning. Duduzi, good morning. I'm going to play your voice note now. Mududuzi, I saw your voice note. Siniko, good morning. Everyone, good morning. Let me just answer Baloy quickly while he's
video be played. So now as we are going, good morning guys, Tutus Makeza here. Guys, as we are waiting for today's judgment, whether the video that was recorded by the witness will be used against the accused number 2. My prediction is the judge is going to side with the state that the video must be used, even though that video was taken whilst they were violating the right of accused number 2. The reason why I think so, yesterday the judge was clear. That's like you want to take the side. You want to listen that video. Judge want to listen that video. So I'm seeing judge allowing that video to be played. So otherwise, they violate the right of accused number 2, but the video will be played. So now as we are going to see that video, well, it changed everything on this case, because accused number 2, if indeed is on the video saying that he killed Meyiwa, it's another thing. It's another thing, guys.
well, that was a voice note from Duduzi there. Yeah, but I think the judge will come with a conclusive arrangement, because I don't think they are going to play it, because the rights were violated like what we saw yesterday. So I don't think it's going to be like that. I was laughing at the comment of Abednego. He's saying, good morning, fellow advocates, more especially good morning, ladies. Guys, there is something that I want you to hear. There's a clip which was recorded of Twala when Mo Flavor was actually interviewing Chico Twala, the longer Twala. So there's something that he said. He said the gunmen were mishandling Kelly, and that's where the fight started. And there is something that he's saying there which is so interesting. I want you to hear this part, guys. I want you to hear this part. I want you to hear this clip once again with me. I want you to listen to the clip while we are waiting for the court to start. I want you to listen to the clip. What did he say? Let's hear what he said. Let's hear what Alonga Twala said.
Our phones, we waited for questioning and everything.
Which phones?
Our personal cell phones.
Oh, okay.
Yes, just,
they hadn't taken them from you.
They took them from us, and then
The criminals, I mean.
No.
Okay.
They couldn't take my phone because I ran out.
ran
I had my
out.
phone in my pocket, so they didn't take my phone.
It's where you're at. It's 8 minutes past 4 o'clock. Welcome. It's The Drive with Mo Flavor and Masichaba and Ndlovu. And we welcome you to The Drive Long. Thank you so much for responding to our invitation.
I'm actually saddened that my own people can do this to me, I mean, it was a robbery gone wrong, I was even the coward of the day, because I actually ran out as those gunmen actually came in and requested phones and money from us. I was actually the first to stand up to try and protect everyone. I wanted to go get help, but it was later. Neighbors and everyone was sleeping. I didn't even have my phone because I left it at the house, so I couldn't call the cops. A fight broke loose inside because obviously Senzo was protecting Kelly because the guys were handling Kelly.
He's saying a fight broke in the house because these guys were mishandling Kelly. So Senzo was trying to protect Kelly because they were mishandling Kelly. Right. let's go this. I have another clip where Kelly is saying she ran to the bathroom. She even forgot that she has got kids. How can somebody who is actually being mishandled run away from that place while is being mishandled? That's what I wanted you to just hear. That's what I want you to just hear about that, because when you look at it, you realize that there is something that actually took place. Longwe is actually saying something which has never been said. On this interview, he's saying something that was not said before. I think if you can hear it, it's totally different from the other version.
Couldn't call the cops. A fight broke loose inside because obviously Senzo was protecting Kelly because the guys were handling Kelly, and then
the guys were mishandling Kelly. The guys were handling Kelly. Kanyisile, yes, he said he had his phone. Why did he not call the police? That's the other thing. He said they did not take my phone, but they took other people's phone. He ran away. So listen, guys, not like you're saying Longwe contradicting himself. They took their phones. Jiki, he had his phone. Yes, you can hear it's too much. There's too much. Let me just play it throughout so that you can actually hear it completely. Let me just play
phones. I went in for questioning and everything.
Which phones?
Our personal cell phones.
Oh, okay.
Yes, just
they hadn't taken them from me.
They took them from us, and then
the criminals, I mean.
No.
Okay.
They couldn't take my phone because I ran out. I had my phone in my pocket, so they didn't take my phone.
It's where you're at. It's 8 minutes past 4 o'clock. Welcome. It's The Drive with Mo Flavor and Masachaba and Ndlovu. We welcome you to The Drive Long. Thank you so much for responding to our invitation.
I'm actually saddened that my own people can do this to me, you know. I mean, it was a robbery gone wrong, you know. I was even the coward of the day because I actually ran out as those gunmen actually came in and requested phones and money from us. I was actually the first to stand up to try and protect everyone. I wanted to go get help, but it was later. Neighbors and everyone was sleeping. I didn't even have my phone because I left it at the house, so I couldn't call the cops. A fight broke loose inside because obviously Senzo was protecting Kelly because the guys were handling Kelly, and then that's when the guys actually released the gunshot, and then that's when the bullet killed Senzo.
Yeah, you can see now there's a bit of a contradiction according to that statement. There's a huge contradiction there with this statement that he has actually said here. Not like saying the guys, meaning it's someone he knew, because if it was the intruder, he should have said the intruders or unknown men exactly. And he's saying the people were sleeping outside. The neighbors were sleeping already. But if you hear from the other testimony, there were people that were up. I mean, there's a lot happening here, guys. And I mean, if they go back and look at those audios, they can actually find out that these guys are just wasting our time. Tembili Slayer saying, yes, true. That's why I am saying, even if they can play that video, we know the truth. I don't care because still is their plan. But I don't think they are going to play it, definitely. Lulama, you're saying to try and protect everyone, but he ran out. You see, that's the thing. He ran out, he was having his phone. There were no people in the streets. But why didn't he call the police? That's the thing. They called Chico rather, because there is another video which I put on YouTube where the actual call which was made firstly was to indicate that Senzo has been shot accidentally by Chico Twala's son. The court is about to start. There is no judge yet. The seat of the judge is still empty. All right, Tokozani are saying he was the first one to run out and choose not to call the cops while he had his phone. Exactly. Temba, you're saying, good morning, my truth-loving family, back in Alice with you. All right, you are back in Alice. Oh, you were in King King Williamstown. I think that's it. You were there. Guys, good morning. I don't think I'm late. Let's see what happens today. Yeah, definitely. Let's see what happens today. The judge is not yet there in court. I just want to play this voice note. I just want to play a voice note. Somebody sent a voice note this morning. Let me just send it. Not like I saying in the evening, at that time of the day in the township, I am 1000% sure somebody saw something or hears something. Could they were paid to keep quiet? Kasi, you know Kasi. I mean, guys, we are from Kasi. We know Kasi. Kasi, Kasi cannot sleep. I call. Kasi is different from town. I mean, Kasi. Guys, Kasi. Sleeping at that time. Kasi does not sleep. Gloria is saying all of the people in the house have different stories. So it's 15 cases to be opened. Yeah, Gloria David, you're right. Sabela is saying manga lona. Yeah, definitely, guys. There's too much. Dabos is saying good morning, ladies and gentlemen. Good morning, good morning, good morning. Let's just hear this voice note. Somebody sent a voice note. Let's just hear this voice note. I'm just looking for a clip that I need to play for you.
Sanbonan, my advocates ekuseni power
Sanibonani.
for sense. Ay bafethu noma ngabe kuthiwa i-recorder ingasho yonke lento ayishoyo lokuthi wavuma untanzi. Uyabona uma ingaboshelwa lapho kuyosho ukuthi umthetho uyobe ungenzi iqiniso ngoba i-DNA ayimfakanga ndawo. I-defense team izoyiveza lento yokuthi lento noma ngabe isidlaliwe, mina nginethemba lokuthi i-defense izokwenza ngcono, khona into ezoyenza noma bangayenzani kodwa iqiniso lizovela.
Yeah, definitely the truth will definitely come out. Definitely the truth will come out. We are all also worried about the issue of the audio, but like what she said, the DNA was not found. The DNA was not found, in which they still want to implicate this guy and put him on the scene. Can you see they're saying nonsense? And it was very early for people to sleep. Yeah, it was very early for people to sleep. There's another voice note that just came in. Let me play this voice note now quickly. Let me just.
Guys, listen very well and proper on that Longway's clip. Longway is saying they didn't took his phone because his phone was on his pocket, and then he say, and then there was no one outside. People were asleep, and I didn't call cops because my phone was in the house. His phone was on his pocket, but Chigi didn't call the police because his phone was in the house. Aye, man.
I didn't hear that part. Let me play it again. I didn't hear that part. Let me replay this thing. There's something interesting. I didn't hear that one. Duduzi, thank you for that. I didn't hear that part. I want to. Yeah, you're right. I didn't actually pay attention to that part. Let me play it once again. Let me play Chico, not Chico's Longetwala's audio. Let me play it.
Our phones, I went in for questioning and everything.
Which phones?
Our personal cell phones.
Oh, okay.
Yes, just
they hadn't taken them from you.
They took them from us, and then
the criminals, I mean.
No.
Okay.
No. They couldn't take my phone because I ran out. I had my phone in my pocket, so they didn't take my phone.
It's where you're at. It's 8 minutes past 4 o'clock. Welcome. It's The Drive with Mo Flavor and Masichaba and Zovu. We welcome you to The Drive Long. Thank you so much for responding to our invitation.
I'm actually saddened that my own people can do this to me, you know. I mean, it was a robbery gone wrong, you know. I was even the coward of the day because I actually ran out as those gunmen actually came in and requested phones and money from us. I was actually the first. to stand up to try and protect everyone. I wanted to go get help, but it was later. Neighbors and everyone was sleeping. I didn't even have my phone because I left it at the house, so I couldn't call the cops. A fight broke loose inside because obviously Senzo was protecting Kelly because the guys were handling Kelly, and then that's when the guys actually released the gunshot, and then that's when the bullet killed Senzo. I left it at the house, so I couldn't call the cops. I wanted to go get help, but it was later. Neighbors and everyone was sleeping. I didn't even have my phone because I left it at the house, so I couldn't call the cops. A fight broke and money from us. I was actually the first to stand up to try and protect everyone. I wanted to go get help, but it was later. Neighbors and everyone was sleeping. I didn't even have my phone because I left it at the house, so I couldn't call the cops. A fight broke loose inside because obviously
the caveat to these charges, the state alleges in the charge sheet that the 5 accused conspired to commit these offences in pursuance of a common purpose. The 5 accused have pleaded not guilty and have reserved their rights and invoked their constitutional rights to silence. The state adduced evidence in order to discharge its owners to prove its case against the accused. During the course of this adjustment of evidence, the prosecutor then decided to lead evidence which related to what he terms statements, confessions, warning statements, and or pointing outs. And it is at that stage that the defense contested the admissibility of all these so-called confessions, statements, pointing outs, and proffered to this court certain reasons which are on record. Because there is a dispute regarding the fact whether the alleged confessions were freely and voluntarily made in terms of Section 217 of the Criminal Procedure Act without coercion and torture. This court then declared that a trial within a trial should be held in order to adjudicate the contention by the state that which alleges that such statements, pointing outs and or warning statements were made freely and voluntarily, whilst the defense adhered to the fact that that was not the case. The state then called Magistrate Cornier as its witness in the trial within a trial because she apparently is the person who presided over the alleged statement or confession, which was allegedly made by accused number 2. Prior to that, obviously, the state also had called Colonel Mboto, who was also alleged to be the scribe who presided over the alleged confession allegedly made by accused number 1. Now, Mr. Mnisi addressed this court and stated that in his view, there should also be a trial within a trial in relation to the admissibility of the audio recording which was made by Magistrate Cronier when she was presiding over the Section 217 interview in respect of accused number 2. My view is that maybe I should commence by saying the defense was given an opportunity by Mr. Baloyi, the prosecutor, to listen to the alleged audio recording which was made by Magistrate Cronier. This emanates from the fact that after Magistrate Cronier had given evidence and before she was cross-examined, the state, through the aegis of Mr. Baloyi, had indicated that it was in possession of an audio recorded tape, but had stated in court that the state was not going to utilize same and try and admit it to the evidence in the trial within the trial. Subsequent to the state changing its mind, and that occurred after the defense had had the opportunity of listening to the tape. The state then said it would appear that in order to bolster its case, it intends utilizing that audio tape and introducing it to evidence because Mr. Baloyi stated that it appeared that the allegations regarding the questions and answers which were elicited and presided over by Magistrate Cronier in what is termed the pro forma format, which is structured on 9 pages and 13 paragraphs, where the information which predicates and precedes the admissibility of a confession or statement has to be argued before this court after the elicitation of evidence and counter-rebuttal evidence by the accused. Consequently, to accommodate the concern of Advocate Nisi, I there and then said, because the precursor, as he terms it, is not apparent to him. To this court, it was apparent in that that precursor is predicated on the fact that the defense is alleging that the rights of accused number 2 were violated, the constitutional rights of accused number 2 were violated, in that when this tape or audio tape was made by Magistrate Cronje, she never sought the consent of accused number 2, neither did she seek to advise or inform accused number 2 in the presence of his attorney that she intends recording the Section 217 interview, and also she intends recording the statement, alleged statement or confession allegedly made by accused number 2. The contrary is that Mr. Baloyi states that even though the recording, the audio recording was made according to him, it was within the state's right to present that evidence. Consequently, then, because there is a dispute regarding the admissibility of the audio recording, this court, because of the fact that there is no dispute from Mr. Baloyi representing the state that Ms. Magistrate Cronje never ever told accused number 2 that he intends recording the Section 217 pro forma question and answer, and also that she intended recording the subsequent allegedly made statement by accused number 2. Now, this court has inherent jurisdiction to invoke the Constitution peremptorily, actually, in fact, the invocation of Section 35, where the rights of accused persons are encapsulated and enshrined. In this instance, the court found it not expedient, when there is no dispute about the fact that this recording of the Section 217 interview presided by Magistrate Cronje the state alleges that it is lawfully acquired, and the contrary, the defense alleges that it was unlawfully acquired. But as I said, because there's no dispute about the fact that it was recorded without the consent and without informing the accused, this court must determine whether the Constitution in that regard, or the rights of accused number 2 enshrined in Section 35 were violated, as argued by the defense counsels here. Now, since the establishment of a democratic state in South Africa and the adoption of the Constitution 106 of 1996, South African courts are enjoined by Section 35 of the Constitution to interpret and promote the values which underlie an open and democratic society based on freedom and equality. And, where applicable, to have regard to relevant public international law, and also to permit the section 35.5 permits our courts to have regard to comparable foreign law. Kentridge, Advocate Kentridge, SC Queen's Counsel, wrote a seminal principle into the jurisprudence of South Africa when he stated that because our constitution is also based on a Bill of Rights, criminal trials in South Africa and criminal appeals should be conducted in accordance with the notions of basic fairness and justice. In the case of Wong Kem Ming versus R 1980, AC 247, PC 261, Lord Halisham stated the following underlying principles. Any civilized system of criminal jurisprudence must accord to the judiciary some means of excluding confessions or admissions obtained by improper methods. This is not only because of the potential unreliability of such statements, but also, and perhaps mainly because in a civilized society, it is vital that persons in custody or charged with offenses should not be subjected to ill treatment or improper pressure in order to extract a confession. It is therefore of very great importance that courts should continue to insist that before extrajudicial statements can be admitted in evidence, the prosecution must be made to prove beyond reasonable doubt that the statement was not obtained in a manner which would be reprobated and was therefore, in the truest sense, voluntarily. In the case of R versus Tamani and others, 1925 AD, Ennis, who was then the Chief Justice of South Africa, stated that it is an established principle in our law that no one can be compelled to give evidence incriminating himself. He cannot be forced to do either that before the trial or during the trial. The principle comes through to us through English law, and its roots go back in history. Wigmore, in his book on evidence, volume 5, in page 2220, traces very accurately the genesis and indicates the limits of the privilege, and he shows that however important the doctrine may be, it is necessary to confirm it within the proper limits. What the rule forbids is compelling a man to give evidence which incriminate himself. Now, it is the norm in trials within a trial for the state to present its evidence and for the defense to present counter evidence or countervailing evidence in rebuttal of the state's evidence. Now, in this case, sorry. This court has to decide whether the audio tape recording, when it was made by Magistrate Cronier, resulted in the invasion of accused number two's privacy and dignity, and that consequently the said audio recording evidence brought whether the said recorded evidence by this tape under the direction of Magistrate Cronier, if it is admitted into evidence, can it be said that it would bring the administration of justice into disrepute, and that also it would be said to be an infringement of accused number two's rights to a fair trial? The gravamen of the accused's submissions, counsel's submissions, is that the reception of the impugned evidence, which is encapsulated in this audio recorded tape, would violate the accused's fundamental rights enshrined in Section 35 of the Constitution. The question is whether it could be argued that this tape can be said to be lawfully made in view of the fact that Ms. Cronier, the maker, was acting in the course and scope of his capacity as a magistrate who is presiding on behalf of the prosecution. In my view, invoking the inherent jurisdiction that I have and following the towering words of Kentridge, if the flouting of the Constitution is so egregious and flagrant, should this court wait until there is rebuttal evidence from accused number two regarding the fact that all he could say is that I never gave consent and I was never asked and I never knew that this interview was taped. And because of the concession by the state, and it doesn't even dispute it, that this tape was made in the course and scope of the taking of the 217 statement. This court has all the evidence regarding that exigency of legality. And in terms of Section 145, subsection 4C of the Criminal Procedure Act, this court is enjoined to decide that legal exigency without waiting for accused number 1, 2, 3, 4, 5 to give evidence in a trial within a trial when there is an egregious, according to me, an egregious flouting so flagrant that why should this court allow it to contaminate the evidence? Consequently, the reasoning this court utilized is the following. The accused has a right to a fair trial, and what infuses its purpose is for justice to be done and to be seen to be done. In considering for the purpose of this case before court, this principle lies at the heart of a fair trial in the field of criminal justice. One has to bear in mind that dignity and freedom and equality are fundamental values of the Constitution, and these are important to the right to fair trial and to ensure adequately that innocent people are not wrongly convicted. And however, there are other elements and rights, such as the presumption of innocence, which cannot be explained exclusively on the basis of averting a wrong conviction, but which arise primarily together with the right to privacy. See in this regard the case of the Director of Economic Affairs and others versus Hyundai Motor Distributors Pty Ltd and others, 2002 SACR 349. Sorry. In my view, the submission by Mr. Baloyi that the inception and monitoring bill is applicable in this case, I beg to differ with him. It is not. When we investigate the reasons advanced by Magistrate Ronje for making that audio recording during the Section 217 interview, she stated that she recorded same for her own personal safety and because she has a penchant for recording any of her duties when she is at work and where there is no recording devices. But the point is, this recordal was made during the course and scope of her employment as a presiding magistrate in a Section 217 interview. Consequently, she may be laboring under the bona fide incorrect impression that she owns that tape. She doesn't. So it is common cause that accused number 2 was not apprised of his constitutional rights by Ms. Magistrate Grenier. And this relates only to the audio recorded tape. It doesn't relate to the section 217 completion of the question and answer format document, which was handed in as Exhibit JJ. The remarks which I'm making relate only to the recordal and the making of the of the auto recording, not to the viva voce evidence which was visited upon by Mrs. Grenier when she was engaging in the interview with accused number 2. Consequently, in my view, I had to determine whether, despite the fact that accused number 2 was not apprised of his rights, and consequently, in my view, he was not informed whether he would acquiesce to the audio recording of the entire section 217 interview and also of the alleged statement or confession which accused number 2 made. This court, in terms of the law, it's entitled to be furnished with a pro forma format document when the maker, when Mrs. Grenier, for instance, was engaging accused number 2 in the interview in terms of section 217. Correspondingly, one would also imagine that this court was entitled to listen to the recorded pro forma questions 1 to 13 of the audio recording. But the defense objected and said that this court will only be indulged by the defense to listen to the tape after I have made a finding either way. That is not the law. I'm entitled. The court is entitled to listen, because we now find ourselves in this invidious position that the defense has listened to the entire tape. And I'm saying, I was entitled to listen to the tape from the inception of the interview right up to paragraph 13. Mr. Balawi also has listened to the tape. The accused also have listened to the tape. And the curious oddity is that the judge who is supposed to adjudicate this matter was disbarred by the defense from listening to the tape. That was an ill-conceived and unlawful But that, as it may, this court still has to deliver these judgments. I wish to differ with Mr. Baloyi when he says the recorder, taped recorder of the section 1-2 interview and even of the alleged statement or confession made by accused number 2 is merely the basis of an electronic version of the pro forma question and answer, that is exhibit JJ. I beg to differ. Mr. Baloyi himself advised this court that there is a difference between what is annotated in the pro forma document, the question and answer document, and what was deciphered when listening to the recording are two different versions, according to Baloyi, in that this is what persuaded him because of the extra information which he gleaned from the tape, that he should adumbrate and bring an application to tender that evidence before this court. In order for the state to supplement the evidential material in the pro forma question and answer, which was completed by Magistrate Ronye, because certain details might not have appeared on the pro forma format question and answer, but are contained in the recording, which is the basis, as it says, of merely an electronic version of the pro forma question. No, it is not. For the following reasons. Sorry, sorry about that. I just. Sorry. Yeah. Yes, for the following reasons. In that, if Mr. Baloyi admits that the court now is confronted with two versions of the interview of the Section 217 interview presided over by Mrs. Magistrate Cronje, it means that we have the original real evidence and the supplementary evidence, which is derivative evidence, and not conscriptive evidence, as recorded by Mrs. Cronje. And despite the injunction in the case of Key versus the Attorney General of the Transvaal, the judgment by Chrysler 1996 in the Constitutional Court, that sometimes the interests of justice and the administration of justice would be relaxed to allow that evidence which is unlawfully and unconstitutionally acquired be made admissible in a court of law. But in this instance, I'm of the view that I demur and say this cannot be done because of the egregiousness of the infraction of accused number two's rights. And further, I've already said that it is not in the interest of justice for this court to wait for the whole evidence to be laid before this court in a full throttle in a full throttle application with rebuttal evidence, and thereafter come to a decision because of the fact that, as we all know, decisions which or rulings which are made on admissibility in trials within a trial, those decisions are interlocutory and may later be reviewed. See in this regard, R versus Meyiwa and others, 1965, 3 SA 529 SRA, a judgment of McDonald AJP, where at 530J it was said, it is important to bear in mind that a ruling of admissibility is not final. Relevant evidence led in the main trial may be taken into account by the judge or magistrate when reviewing his decision on admissibility, no matter what the source of such relevant evidence might be. There is no reason why this should not also be the position with regard to when a trial within a trial is held. And another point is that in S versus Muchindu 2002 SACR 313, Witwatersrand, Schulz, as he then was, at 3161, stated that a ruling on admissibility in a trial within a trial is interlocutory and may be reviewed at the end of the trial in the light of later evidence. S versus Mkhwanazi 1991, 1 SA 736A, this principle in fact shows that subsequent evidence in the main trial may decisively alter or affect the determination of the issues in the trial within the trial. But in this case, I want to view that the accused number two's rights to a trial, to a fair trial, were infringed by the making of the audio recording by the magistrate Ronje. And consequently, as from the time the accused number two's rights were infringed in that manner, this court doesn't have to speculate that perhaps the accused number two would have later said he doesn't mind that these Section 217 proceedings were recorded. But this court is enjoined to declare evidence which was acquired unconstitutionally to be inadmissible, as I'm doing about the very recordal of the Section 217 interview from its beginning to its end. Because if this court allowed such an egregious flouting and flagrant flouting of accused number two's constitutional rights in terms of Section 35(5), it would not be in the interest of justice to do so, because accused number two would then be continuously subjected to a trial unfairly, when we know that the Constitution engages us and enjoins us to prevent such an exigency. And also, in the view of this court, that would bring the administration of justice into disrepute. Consequently, this court rules that the audio recording should not form part of these proceedings. It is inadmissible. Okay.
yobufakazi bala inkantolo ishike ngokomthetho ukubhekela phansi kwamalungelo akhe ummangalelo wesibili inkathi ke engatshelwanga ngayo i-recording isinqumo ke senkantolo ukuthi ayingeke ibe ingxenye yobufakazi bala enkantolo i-audio ukhulunywa nge-audio nje kuphela noma i-recording magistrate awayenzi.
Okay.
It's is available for further cross-examination on Exhibit JJ.
Right.
Yeah. Ms. Grenier, she's just outside.
What's your time, admissible?
Just after 10 past. Maybe we can take the normal short adjournment.
Yeah, we should.
And resume at.
Yeah, sorry about that. Can you reassemble at 11:30? Thank you.
Hi guys. That's a good decision there. I was waiting for that. Guys, I wish the defense team can just ignore this Cronier. They just ignore her once. They must just ignore her once. They must not even ask her questions or do anything. Oh, Judge, thank you. Oh, thank you, Judge. Oh, Judge. Guys, let's get Judge something to drink or what? Yeah, no, guys, no. I think Judge deserves a stony. But guys, look, I mean, the evidence was going to be actually a problem. Why? Because it was done without his consent, and he was not even told his rights. Hi, Baloy. Do you know the reason why Baloy is trying to pin this young man is because this young man is the one that was actually supposed to say they were together with all these other one. Franz, are saying Judge Basson, thank you. Oh, we've forgotten. Not like saying today, my lord. Zomfakisa Sandler. Indeed. Yeah. Let me hear your voice notes. Let's hear your voice notes, guys. Let me hear your voice notes. Oh, yay. What a scene today. Yo, hi. Let's hear your voice note. What is this one saying? Is this voice note coming in? Yeah, let me hear this voice note. Somebody just sent a voice note. Let's hear the voice note.
Hi guys. Hey guys, sekumele siqale manje ukuthi silalele simbuke le judge ngenye indlela. Le judge liyayibuka into and manje futhi ijaji le judge leli liyakwazi ukucubungula izinto, kumele siyibuke kahle izinto, singajaheli ukuthi silwe. Ake simnike nje ithuba lo baba uyayazi into ayenzayo, sizobona iqinile.
Yeah, guys, I'm telling you what actually transpired now. I'm excited. I'm actually excited. Definitely, the judge actually came through for us on this one. Because definitely, Agnes is saying deserve a special birthday present, my lord. Definitely. But guys, you see, the thing is, Baloy is wasting our time. Baloy is wasting much of our time. Yeah, much of our time. I'm telling you, it's something else. I'm telling you, it's something else. Can you see the order? Can you see the and non-transfer order in court? Order, advocates, order. Abednego, you're saying I'm so happy. I feel like running up the road naked. Yeah, naked once. Yeah. Yeah, I know, definitely no. You see, sometimes we need to celebrate small wins. You see, if we crush Baloy, sometimes we need to celebrate small wins. They are good for us. We need it because we need motivation. Today, this is a good motivation. Even if they stop the case now, I don't have a problem. What they've just done, what was done today, it actually makes me to be all right. The judge was even drinking water today like no one's business. Carry drink some Hennessy. Fania saying you were right, boss. You see, I was busy. I was prophetically seeing something in the realm of the spirit. You see, I was seeing some things happening in the realm of the spirit, and I saw that this thing was going to be rejected. In the realm of the spirit, I saw Baloy fainting. Franz, you are saying on my way to Top Spa to buy Judge Bason Jameson. Hey, yeah, man, no, he deserve one. He deserve a bells. Tomela, you're saying, can you summarize again? Right, it's all about the evidence. The evidence that was brought in by Baloyi, that Miss Cronje, the judge, Vivian Cronje, brought in, was an evidence that was recorded whilst Ntanzi was forced to make a confession. Ntanzi was forced to make a confession. According to the defense attorney, he was beaten and it was done under duress. So now, the mistake which Miss Cronje did was that she did not actually read this particular individual his rights, to say that these are your rights. You have the right to remain silent. You have the right to do this. The rights were not actually told to the accused. And to make matters worse, she recorded this for her own personal copy, her own personal copy. You see, so that's where the whole issue is there. That's where the whole issue is. Chivula is saying, guys, let's appreciate the decision which was taken by the judge. Bless him. Yeah, it's true. Duncan is saying the judge said this court have all evidence. Really, he is knowing what happened to Senzo. Yeah, definitely. No, he knows. Definitely he knows. Doctors, where have you been? You're saying I'm late. Evelyn, you're saying thanks, Mr. Judge. Definitely. Sposh, you're saying she needs to be asked some questions because in her witness, she said she was told that she's a threat. Really? Okay. Dudu, they're saying thanks, Judge. I can't wait to see Ngome Zulu. Definitely. There's a voice note that has come in. I'll play it now. The judge said this court of evidence. All right, read that one. Obako, you're saying, but why do they need to cross-examine magistrate? No need. It's a waste of time. Definitely. Obako, that's my sentiment. That's what I'm actually talking about. We don't need it, guys. We don't need it. We don't need it. We don't. Let it go. By saying this whole case is based on accused number 1 and 2 because these two are supposed to implicate the 3 accused exactly. Mzukisi are saying what the judge has done this morning, Baloyi can't undo it. Oh, yeah, 100%. 100%. Tabang is saying, guys, anyone who is aware of the content of the recording, please share some facts. Not yet, we haven't get our hands on that. Non-translator saying, Mina, I'm happy for Ntanzi boy and his family. Yes, definitely, guys, we are excited. Let's hear this voice note.
Babenzela le tape ukuthi ba-ede kulamanga abo ukuthi si-ede balanda futhi umuntu ababazi ukuthi usebenza wona ukutape la ngeke aphikiseke ngoba uyi-magistrate. Babenzela wona ukuthi amanga akhe lawa aqinisa icase ukuthi uzikhulumelile sazi samtape ilahla la sebe bengasamtsheli yena okucaca la yayikhandwa yonke lento iconfession babezama uqinisa icase econfession ukuthi hayi size samtape okomthi ukuthi wekhululekile ezikhulumela kuleyo tape kanti bamshanga uZulani ukuthi athi mehuma ngala bese yalokhuza kanti kule tape wazi ngani makunezinto ezicishiwe sacishwe ezinye zazithi hayi kodwa ngazani nalento bakhathe lokho bathi hey wena bamvumise lokho abamvumisako kudlaliwe ngabantu kule case le kuqiniswa icase eweek engekho la abantu abasendlini abakhulume guys utsek man.
Yo, hey, who is this guy? Who is this one? Who said this voice note? Hey, guys. No, guys. Not like that. Well said, Mr. Voice Note. You nailed it. That's what not like they're saying. You nailed it. Definitely, you nailed it. Sifisi is saying happy for you Ntanzi in your family and your family. Tembe Little is saying we need the people who were in the house. Finish and clear. We need the people that were in the house to come in. definitely we need them. They must come in. Duduzi are saying, thanks, Judge. I can't wait to see Ngomezu. Okay. Let's see. There's another voice note that has come in now. I want to play this voice note quickly. I want to see this voice note that has come in now. But yeah, this is going somewhere now. I'm actually excited with what is happening here, because definitely there's a lot that is actually taking place. Let me just play this audio for you quickly so that we can just hear it.
Hi guys, it's a good news for the defense team on what the judge said about the recordings. On the other hand, on the side of the state, it's a bad news, because I think Baloyi and his friend Gininda, after they find out that there is a recording, this recording will make their case strong, because they will gonna use it as an evidence. I think gonna be a bad lunch for these two guys, Baloyi and Gininda. But let's congratulate the defense team, especially Advocate Mngomezulu, and for that input. So it's a bad news for Baloyi. So sorry for him.
Yeah, guys, the judge said the recording that magistrate, the one that is witnessed now on the stand, record is different than this evidence that Baloyi. That's why Baloyi was want to use that record, because that record got extra information, got different vision. So where did this witness get what she wrote? Because if she did record, and then on the record there's different story, and then on the writing there's different story, why we are not throwing that evidence outside of the court? Now I'm waiting for Ngomezulu to cook this magistrate, because this magistrate is also on Bericele and Gininda's payroll. Hayi man, ayikho lento yakho. Akambuza umbuzo oqondileyo ukuthi ungani kunomehluko phakathi kwe-affidavit yakho lalokho okwakuqophayo. Hayi kabuzwe lo muntu man.
You see today Baloyi won't sleep. He won't sleep. And you know the word. The word says the wicked shall not find rest. He will never find rest. You know, the guy is wicked. He is wicked. And now God is starting to show him flames. Since he has lost this one, he will continue losing. He will continue losing. Let's pray for Ntanzi and his co-accused.
Zuki is actually quoting the scripture. He's saying the wicked will not find rest. They will not sleep. Definitely no. They will not have actually a good sleep. But we have actually seen that this evidence, like there's another voice note that I was listening to where someone was saying that the one that is there, the evidence is not the same. He dismissed the first evidence, and these people, they did not go through it. He comes back again. He's now saying let that evidence be brought into court and let it be used. So there was a lot of actually things that were not right along this issue. There's something that was not making sense. Today, Baloyi, I'm telling you, today is actually he needs brufen, because it's not well with him as we speak now. He needs serious painkillers. If we can organize, if there's somebody who is near to the pharmacy, please just go and get some brufen and some grandpa for this guy, because he's stressed. Too much stress. Stress. Why are you saying Magistrate Skronje, the whole magistrate is making such a big mistake of not telling Ntanzi his constitutional rights? Exactly. That's why you see that it was actually fabricated. Shengu, you are saying, good morning, family. What's happening? Where have you been? Where have you been? Continue to listen. You'll catch the flow. You were supposed to come, but it's fine. as we are talking, you're going to hear much of the things that took place. You will hear some of the things that that took place. Tokozile are saying, thanks, Judge. Come on, Miss Kronye. I so wished advocates Komezulu can just crush her into pieces. I don't even want her to come. That's my thing. Guys, let her not come. She's wasting our time. Why do we need to continue to ask her for the things that was dismissed? So I think these defense guys, they just, I don't know what's your take. I think the defense guys may just let her go because we don't need her. Because everything that is going to be coming out of her, it's just lies. Why are you saying no, we need her to be cross-examined? Remember, there is a pro forma completed by Magistrate. Okay, Advocate Nkome Zulu must crush her because she was supposed to record the pro forma. Oh, okay. Because to me, I was actually pushing her away. That's why 375 docket is ready now. Okay. Yeah, we need that one. That one we need it. Mercy are saying we speak the blood of Jesus. In this case, we are getting there. Hallelujah. 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 You're in the spirit. Brad Boss, you're saying, so what can happen? These four guys, after so long, hey, Avaler, there's going to be something else. If they are innocent, I'm telling you, there's a lot of payment to be done there. There's compensation that needs to be done because their time has been wasted, their reputation, everything. There's a lot at stake, so they can't afford to lose this case. That's why they are saying that. Nonetheless, they are saying we need a new witness. Yeah. We need that witness to come. Really, I agree with you. We need a new witness. Obako is saying we'll give Baloy Allergex, not Brufen. We want him to sleep until next year. When are they going to come back live? They said 11:30. I think so. You know them. When they say 11:30, they will come at their own time. Mina, I can't wait to hear Ngomezulu cross-examine in his claim, but bombing state. But definitely, he will actually silence this one. I know this one. If he comes in, he will silence it. Maboto is saying Baloy and his friend Gininda. No, those guys are too much. Tiamo is saying we are praying for the accused because the culprits are roaming the streets. Definitely, they are free. They are free. They are free. Definitely, they are free, and it's painful because they are free. The guys are free, and they don't have any stress at all. I wonder how they sleep anyway. Shengu is saying, Yazi, my day is flowing. I need one. I wanted to play a voice note. Sorry, I wanted to play. There's a voice note which I wanted to play. I wanted to play a voice note. I don't know. It's downloading. All right, fine. Where was I? Tokozile are saying Chico Twala, wherever he is suffering from diarrhea, and now phone calls are going everywhere. Kelly, Zandi, Tumelo, Mtoko, Ntombi, Mapiri. We are coming to you soon. This is obvious, guys. These guys are going to be set free, definitely. Where were you, Ngomezulu, all along? There, that's the voice note I was checking. I was looking for this one. I was looking for this voice note. Let me just play this voice note quickly.
Ladies and gentlemen, I want to take this opportunity and say thanks to the judge for the decision he made today by rejecting this recording that was brought by the Baloy with the state. It is very clear that the state, particularly Baloy, is in the payroll of the Komado. So they paid him to bring all this nonsense. Please, I know that you know what you're doing. Take your time. Thanks to the defense. Be patient and do exactly what you're doing. I can say now you're going to win this case because it is clear. Senzo Meyiwa was killed. People were in the house. They know exactly what transpired that day. Thank you.
Thanks, Bafo. It's true, and definitely the truth will always come, right? And I know that we will definitely get to the bottom of everything that is happening here. Franz wrote a message. He said, "Lord, Baloy is unpredictable. He might surprise us and call his wife as an evidence." Non-translate saying, "Do you think when you are safe, he will call you too?" Guys, you guys, you guys, you're too much. Clement is saying, "Mashandu mtia, be careful, Leo Savannah." Ngakwenzi njalo. Yeah. As Boji are saying, now we need Kelly, Makumalo, Longwe, and Mapi. Yeah, definitely we need them to come in. They have to come in. They are overdue. We need them to come in now. We need them to come in. That was Toko's concern, so we want them to come in. Mkome Zulu for presidency. I know we want him first as a judge before he become a president. We want him. We have not. We have too much drama now. We need somebody who can actually deal. Not, you see, the issue of the judge picking up, and Baloy picking up cases of 1965, 1955, 1945, Basson versus what, Windmill versus Castle Light versus Black Label. All those things of 1965, they are not working. They are not actually relevant. The laws, they changed just after the apartheid time, because now people have got rights. That time they were not having rights. So now they can't just come in and actually use such laws and try to justify certain things because of that. So they must work with laws which are above the apartheid era, so that they can actually work relevant to the current laws, because they were using the former laws. That's where the problem is. Baloy has been actually quoting the previous laws. Mduduzi is saying, "I'm getting a call from a new number. Maybe Baloy want me to be a witness." Yeah, he wants you to be a witness. Definitely, you people are now, are now worried, because at the end of the day, what we need to see is these guys come out from their prison cells. They need to come out, definitely. We need them to be set free, because they've been there for a long time, actually, for certain things which they did not do. That's the thing, which they did not do. And I don't know why they are pinning accused number 1 and 2 that much. Like somebody said that, remember, they wanted to make sure that they implicate the others. Let's go back to the voice of Longwe Twala just for a while. There's something that I want us to just clarify. The Sitlolo is saying, that is not translated, saying, "We are not, Nami, I'm scared. He might look for me." I definitely. Gloria is saying, "I am quiet and listening." I can see, today you are quiet. Today you are quiet. Today you are very quiet. Not realizing these laws were in favor of the apartheid regime. Definitely. That's why there was no fairness in the trials that were done during that time. There was no fairness. So now there is now the new sheriff in town. So yeah, we need to actually find out and see how everything goes down. There's a voice note which I also wanted you to hear. Where is it? Where did I put that voice note? Where did I save it? There's a voice note which I want you to hear as well. Not a voice note. It's one of the clips, but I will not put the video in. I'll put the voice. The voice will be running. I want you to hear. It's about the it's about the
It is further correct that You were approached on the 24th of June 2020 to take
Our phones,
a confession.
we did question and everything.
Which
Is
phones?
that correct?
Our personal cell phones.
Oh, okay.
Yes.
They hadn't taken them from me.
Bekentenis te vat. Ek was nie bewus van wie dit gevat sou gewees het nie.
I was approached to take a confession. I wasn't aware as to from whom was the confession going to be taken. Mina kwenziwa ukuthi nje ngacelwa ukuthi ke angithathe ke confession ukuthi yayizokwenziwa kwakuubani lo uzokhuluma angikwazi ngamafutha.
Dit het eers later my bekend geword dat die persoon wat die bekentenis wou aflê, 'n meneer Bongani Sandisu Ntanzi is.
It only became later, it became known to me later stage that the person or the deponent was Bongani Sandisu Ntanzi. Into engazoyazi kamuva ke ukuthi umuntu ke ozoyenza ke le confession kwakuubongani Sandisu Ntanzi.
So, for the benefit of the public, it is correct so that the said confession was taken in terms of section 21A, in terms of section 217, 1B, Roman figure 2.
Dis korrek.
That is correct. Kuyiqiniso ke ukuthi ke i-confession lena yathathwa ke phansi ke wawo ke lowo mthetho lewo section 217.
Ma'am, it is correct that you took the said provision. It talks about the accused. Is that correct?
Nee, kan nie saamstem nie. Ek het die bepaal, is dit nou nommer 2?
I cannot agree with you there.
Dit verwys na die woord person, nie accused nie. As jy maar net kan verwys na die deel waarna u verwys.
If you were just to refer me to the portion that you are, because here it refers to a person, not an accused. If you can direct me to where to which point you exactly mean.
May I consult, my lord?
You're reading the section.
Yeah, yes, sir, the
217,
217, my lord.
sub 1
B.
B. Dis korrek.
Sub 1B,
As jy
that's
maar net
correct.
daarna kan verwys, want ek kan nie die woord accused daarin opspoor nie.
Because if you can just point out, because I cannot see or trace the word accused in here.
It reads of such person against such person.
Such person, yeah.
So ek sien nie die woord spesifiek daai.
Thank you.
I don't see that specific word. Angiliboni ke leli gama ukhuluma ngalo ke lana ikhuluma ngomuntu ayikhulumi ngomsola noma ummangaleli.
Thank you for the correction. I would like to retract that question. Let me withdraw it. Let's proceed. May I consult you? No, I'll go through this. It's fine. Thanks. Thank you. In relation to the provision that we were dealing with, section 217, it is indeed so that after taking a confession, it must be reduced into writing. Is that correct?
Dis korrek.
That is correct. Kuyiqiniso ke ukuthi emuva kokuthi ke ngithathile ke noma la umuntu avuma khona ke lokho akushoyo ngikubhale phansi.
The prerequisites of that provision is that the person who is from whom you are taking a confession must make such a confession freely and voluntarily in his sound and sober senses. Is that correct?
Dis korrek.
That is correct. Kuyiqiniso ke ukuthi umuntu uma ke ezokwenza confession fanele akwenze lokho kuphuma kuyena ke futhi esemfondweni ke ngokuphelele.
And it further states that it must be made without being induced or coerced or made under threat. Is that correct?
Ja, dit lees without having unduly influenced.
That is how it reads. Yes, ifundeka ngaleyo ndlela ke ukuthi angaphoqwa ke umuntu noma kube ukuthi akaphoqiwe ukuthi akwenze noma ke akhulume lokho.
For the benefit of the public, the same provision under section 2171A provides similar prerequisites. Is that correct?
You can say ja.
You can say so, yes. Ungasho ke nokuthi 217 leyo ke 1A nayo ke usho kanjalo.
But the only distinction is that the provisions in terms of section 2171A, it is made by a non-judicial officer. Is that correct?
That's correct.
That is correct. Uyiqinisoko ukuthi yena ke u2171A wenziwa ke umuntu ongasiyena ke umantshi noma ke umehluleli.
In the same provision of section 2171A, it also requires the confession to be made in writing. Is that correct?
That's correct.
That is correct. Kwa futhi ke loyo 2171A ke uyasho ke ukuthi confession leyo kumele fanele ukuthi ibhalwe phansi.
It further makes a provision that that particular confession shall only be admissible unless it is reduced into writing in the presence of a magistrate or justice. Is that correct?
That's correct.
Nokuthi ke that is correct, yes. Nokuthi ke futhi lokho kuzokwenzeka ukuthi yamukeleke ukuthi uma yenziwa ngaphambi kwakhe ke umuntu oyimantshi.
If that as a magistrate, if that confession in terms of section 2171A is made by an officer but not in the presence of a magistrate, you regard that as a properly taken confession?
Sover ek verstaan, as daar enige bekentenis gemaak word aan byvoorbeeld 'n polisie of 'n persoon wat nie die rang van offisier dra nie, met ander woorde is 'n laer rang.
As far as I know, as far as I understand, if a confession is made to a person who is not an officer or a person who is lower with regards to a rank, ngokwami ke ukwazi uma ngaba ke i-confession leyo yenziwa ke futhi yenziwa kumuntu ke ongasiyona ke i-officer noma ke ngesikhundla ke unesikhundla esiphansi noma esisenzansi, yeah,
dan moet daardie bekentenis voor 'n landdros bevestig word.
And then that confession needs to be confirmed in front of a magistrate or before a magistrate. Okusho ukuthi ke leyo confession leyo kuzofanele ke ukuthi ke inikezwe isiqinisekiso ke ngaphambi kwayo imantshi.
Dit is nie myns insiens nodig dat 'n landdros fisies teenwoordig hoef te wees op die stadium as daai bekentenis geneem word. Maar dit moet nog steeds in skriftelik geneem word en dan bevestig word weer voor 'n landdros.
It is not necessary for it that a magistrate should be present when it is made or when it is taken down, but it needs to be confirmed, or the confirmation part needs to be confirmed in front or before a magistrate. Akusi ukuthi ke uma yenziwa ke kufanele imantshi ibe khona noma magistrate abe khona, kodwa uma isiyoqinisekiswa ke lokho kwenziwe phambi kwakhe umantshi.
And really in hierdie spesifieke geval was dit nie 'n konfessie of 'n bekentenis in terme van artikel 1 sub A nie, aangesien die persoon wat die konfessie afgelê het aan my aangedui het dat hy geen ander soortgelyke verklaringe gemaak het nie.
But with regards to this particular one, it is not a confession that was made under section or section 1 sub A, seeing that the person who or the deponent of the confession informed me or indicated to me that he had made no other confession or confession which is similar to this. Lapha ke phansi kwakhe ke usection 1 lona ke usub A besingekho ke isidingo saloko ngoba ke lo muntu ebenza ke le noma besenza le statement ephambi kwami ushilo ukuthi ayikho enye ayenzile enjengalena.
That's correct. The thing is, your evidence is that this is how you understood section 2171A.
That's correct.
That is correct. Ngishilo ukuthi indlela ke leyo engimuzwa ngayo noma engim-understanda ngayo ke usection 2171A.
But my question did not relate to how do you understand section 2171A. My question related to what is prescribed by the Act of Parliament. Unless you want us to read the whole section. For you to understand,
you can read it.
You can
read it.
As a brief.
He says you can read it.
Sorry?
He says you can read it.
My Lord, may I read it with the assistance of my attorney? Mr. Who is this?
As the court pleases, my Lord. My Lord, section 2171A, the section 217 says admissibility of confession by accused, and 1A says, and I quote, that a confession made to a peace officer other than a magistrate or a justice, or in case of a peace officer referred to in section 334, a confession made to such a person, such a peace officer, which relates to an offense with reference to which such a peace officer is authorized in exercise any power conferred upon him under that section shall not be admissible in evidence unless confirmed and reduced to in writing in the presence of a magistrate or justice.
Thank you, my Lord. Did you understand it?
That's correct.
That is correct.
It does not relate to any rank of the peace officers. Do you agree?
Correct.
That is correct. Peace officer.
So it differs with the way you understood it. Do you agree now?
That's correct.
That is correct.
Let's get into the date in which you said you were informed by Mrs. Du Plessis, or you were requested to take a confession. Is that correct?
That's correct.
That is correct.
The communication between yourself and Mrs. Du Plessis, was it in writing or verbally?
Telephonically. Inkulumo phakathi kwami ke no Mrs. Du Plessis okuyena ke wangicela kwakungocingo.
So the details of what you discussed between yourself and Mrs. Du Plessis cannot be confirmed if she is not called to confirm such conversation. Is that correct?
That's correct.
That is correct. Yebo ke okwakhulunywa ke phakathi kwami naye angeke kube kuqinisekiswe ke uma engabiziwe
So that part of evidence can be provisionally accepted unless or until Mrs. Du Plessis is called to testify in order to confirm that conversation. Is that correct?
Die regter het reeds 'n uitspraak daaroor gegee toe ek die getuienis gelewer het.
The judge has already made a ruling with regards to that when I testified.
En sover ek kan onthou, was dit aangedui as dat dit geskraap moet word wanneer is hoorsê.
And as far as I can remember, it was indicated that it should not form part of the record because it is hearsay.
Maar,
sorry, okay.
Ten opsigte van u vraag, dit bly die keuse van die hof en die staatsadvokaat wat hulle met daai deel wil doen.
But with regards to your question, it remains the choice of the court as well as the state as to what they are going to do as far as that is concerned. Kuyiqiniseke ukuthi impela ke angeke kube nesiqiniseko saloko kwashiwo phakathi kwami nayo uMrs. Du Plessis, kodwa ke inkantolo ibisisikhiphileke isinqumo nkathi ninikezela ngobufakazi ukuthi leyo ngxenye yobufakazi ke ukuthi ingamukelwa ke nanjengokuthi into ukuthi akekho lo muntu lona engikhuluma ngaye ukuthi kuzokwenziwani ke emuva kwalokho isinqumo senkantolo kanye nayo umshushisi.
When you arrived at Boksburg Court, it was 2:30, subject to correction, but I heard that it was 2:30.
Nee, dit was 2:25 min of meer.
No, it was more or less 2:25. Isikhathi ngafika ngaso eBoksburg ngathi kwaku 2:25.
2:25. And when you entered the court building, or when you entered towards the office that was prepared for you, that is room 2, you saw police officers who were heavily armed. Is that correct?
That's correct.
That is correct. Kuyiqiniseke ukuthi ngathi mangena lapho ngabona amaphoyisa ayehlomile.
Were you not frightened?
Nee.
No. Ngangasabi.
When you noticed somebody that was handcuffed, that was an assumption that this is the person who's coming to take a confession. Is that so?
That's correct.
That is correct. Yabo ke uma ngabona ke umuntu ofaka ozankosi la engacabangela khona ukuthi uyena ke lo muntu lona uzokhuluma noma uzokwenza confession.
The person who was wearing the suit, you said, did you manage to know who that person was?
That's correct.
That is correct. Yebo kuyiqiniseke ukuthi ngaye ngamazi ukuthi wakubani lo owayegqoke isuti.
Who was that person?
Die persoon het homself voorgestel aan my in die kantoor as meneer Dominic Mjiako.
The person introduced himself to me in the office as Dominic Mjiako. Wayichaza ke lo muntu loyo nanjengo Dominic Mjiako.
Sy volle naam en van het ek egter van die dokumentasie gekry wat hy aan my oorhandig het.
But his full details or his full names as well as his surname, I got those from the document that he provided me with. Kodwa ke amagama akhe aphelele ngawathola ke kuloko noma ke document awayenginikeze yona.
Let's just start with Mr. Mjiako Dominic. It's your evidence that you satisfied yourself that he was an attorney. Correct?
Yeah.
Yes, yebo ngayineza ke ukuthi waye ummeli noma nganyela ke ukuthi ummeli.
But there was a distinctive feature that actually happened, or you treated him differently from other police officers. Let me just put it very straight to say you did not make the copies of the Fidelity Fund certificate and the appointment certificate. Is that correct?
That's correct.
That is correct. Kuyiqiniseke ke ukuthi ke i-certificate sakhe ke nalesi se-Fidelity Fund angiwenzanga ama-copy alokho.
And you made the copies of the officers, including the officer Mr. Mujano, and you attached them on the pro forma. Is that correct?
Ek het self nie die afskrifte gemaak nie, hulle het die afskrifte gemaak en in die kantoor ingebring net voordat ek begin het met die bekentenis.
I did not personally make the copies. They made the copies and brought those copies to the office just before I started with the confession. Akuyimina ke owawenza ke layo makopi uma khuluma ke ngomuhane ngibona abahamba bayowenza base bewaletha ke ngaphambilini nje ukuthi ngiqaleke ngenze leyo confession.
But at your request, is that so?
Dit is korrek.
That is correct. Lokho bakwenza ke beyicelwe yimina.
But you never requested the copies of Mr. Mjiako to be the FFC certificate and the appointment certificate. You never requested it to be copies to be made out of them. Is that correct?
That is correct. Kuqiniswa ukuthi kaMjiyako wona ke amaphepha angizange ngicela ukuthi akwenziwe amakopi awo.
And Mr. Mjiako, that Dominic Mjiako, unless if he's called to testify, what he told you cannot be accepted in court as hearsay evidence. You agree?
Dis korrek.
That is correct. Yebo ke angitshela kona ke uMjiyako lokho angikwazi ke ukwamukeleka enkantolo njengokuthi into engayizwa ngoba ngaphandleni kokuthi abizwe eze yena azofakazi.
And that failure to prove that evidence cannot be corroborated by the copies that should have been attached in the proforma. Do you agree?
Daar is geen kopie aangeheg wat die inskrywing op hierdie bekentenis tot daai effek bevestig nie. Dis korrek.
That is correct, yes. There is no copy made with regards to that which is attached to this confession. Kuyiqiniswa ukuthi ngempela akayikho ke icopy yaloko noma lokho bhaliwe lapho ekhona noma eyingxenye yale statement lesi.
So this honorable court cannot accept the evidence of a discussion between yourself and Mr. Mjiako. Do you agree?
In terme van wat?
With regards to what?
The conversation between yourself and Mr. Mjiako, who said is the attorney, Dominic Mjiako.
Dit is bevestig deur die persoon wat die bekentenis self gemaak het ook en hy het hierdie man uitgewys ook as sy prokureur. En hierdie man het bevestig dat hy die prokureur is. So ten opsigte van die voorsittende beampte myself moet ek aanvaar as 'n persoon 'n bekentenis kom aflê en hy self wys na hierdie man en sê dit is sy prokureur en hierdie man bevestig dit dat dit wel so is.
This was mentioned or was said by the deponent of the confession, and then the person himself confirmed that indeed he was the lawyer. Now I, as the presiding officer, the person who was now taking down the confession, then has to accept that indeed if the person, the deponent says this is his lawyer and he confirms that it is indeed so. Lokhu ke kwakhulunywa uyena ke lona owayezokwenza istatement ukuthi ummeli wakhe. Naye ke lo ekuthiwa ummeli naye ke wase eqinisekisa ke lokho ukuthi ummeli. Nanjengemantshi ke mina ke engizokwenza ukuthi ngamukeleke ukuthi lokho abangitshela kona ngempela kukanjalo.
Ek het myself vergewis met die dokumentasie wat hy voorgelê het, met dit wat die persoon wat die bekentenis afgelê het aan my meegedeel het, asook hierdie prokureur. Maar u is reg. As die staat, as hy dit in twyfel getrek word dat hierdie persoon sê wie hy is, dat hy nie 'n prokureur is nie, dat hy my as voorsittende beampte mislei het, of dat daar 'n bewering is dat die persoon glad nie eers daar was nie, dan moet die staatsadvokaat toesien dat hierdie persoon geroep word. Wat my betref in daardie omstandighede, was ek tevrede dat en oortuig gewees dat hierdie man sê wie hy is en dat die persoon wat die bekentenis aflê wel ook tevrede is met hierdie man wat sê dat dit sy prokureur is en dat dit die persoon wat hy aangestel het.
This was said to me by the deponent, and then the documentation was then provided or shown to me. I certified myself with that which was said by the deponent, as well as the documentation, that it was indeed the case. If now there is this allegation now from your side that this person was not a lawyer or was not an attorney, or that this person was never there, then indeed, yes, as you say, the state will then, or that this person misled me as the presiding officer, then of course it is incumbent upon the state to then call this person to come before the court.
Thank you.
Lokho-ke okwashiwo uloyo owayenza istatement kumina. Ngase nginikezwa-ke nephepha-ke noma-ke idocument emchazayo-ke ukuthi ummeli lo muntu. Ngase nginize nezakho ukuthi ngempela lokho kukanjalo. Uma-ke kuwukuthi lokho wena-ke okushoyo ukuthi cha lo muntu wayengekho lapho, wayengasiyena ummeli noma wangikhohlisa-ke mina, uzosho-ke ukuthi kuzofanele ukuthi eze phambi kwale nkantolo azokusho-ke lokho.
Die tolk was natuurlik ook teenwoordig tydens die hele voorval en is ook 'n getuie tot wat plaasgevind het in die kantoor.
The interpreter was also present during the proceedings and is also a witness with regards to what happened in the office. Utolika-ke naye-ke wayekhona-ke lapho futhi-ke ufakazi-ke mayelana nalokho okwenzeka ehhovisi.
Ma'am, I said let us just start with Dominic Nchiako. My question still stands. What you discuss, forget about the deponent. What you discuss between yourself and Dominic cannot be confirmed at this moment. Is that correct?
Ek het die vraag reeds geantwoord. Ek staan by.
I have already answered the question. I maintain that which I have already said. Senguphenduleke lo mbuzo njengobuza ushobo ukuthi okuwakhulunywa yimina-ke noDominic angeke asikho isiqinisekiso sawo. Sengiphenduleke kuloyo mbuzo.
And I'll further.
Sorry, Mr. Mgomezulu. Sorry.
Sorry.
This witness adds a rider that the interpreter was present when this gesprek, when this discussion happened. Are you saying that, ma'am?
Dis correct.
Yeah, that's the rider she adds.
My lord, I'll come to the evidence of an interpreter.
No, fine.
The
but you're just
important.
saying the witness adds a rider. You see the problem here, she's testifying in Afrikaans. And you have as machtig in Afrikaans. So that rider was not interpreted.
No, I did, my lord.
No, you interpreted it the first time. Are you with me? But when she says end, the talk was that so.
I did.
Okay, fine, sorry.
Okay.
No problem.
So, to your knowledge, you are not sure if, okay, let me just put it this way. Let's get into, I'll just sum up my questions in relation to Mr. Mjiako by saying, other than a confirmation by the interpreter, there's nothing that you can confirm that Mr. Mjiako was present on that particular day.
Die kliënt kan dit bevestig.
Your client can confirm that. Njengoba uthi-ke ngaphandle kotolika akukho kunye okungaqinisekisaka ukuthi uMjiako wayekhona, lona omeleke angakuqinisekisa.
It's my instruction that he was not represented on that day, and he does not even know Mr. Mjiako. It's my instruction. That's why I'm still insisting on the right to legal representation.
As dit u instruksie is, dan vertel u kliënt nie vir u die waarheid nie.
If that is your instruction, then your client is not telling you the truth. Ukuma kungaba-ke lokho uthi-ke lona ommele ukutshela lokho-ke ukuthi wayengamelwe ngaleliya langa kusho ukuthi akakutsheli iqiniso.
All right. If that is so, he's not telling me the truth. I just want to establish, because you said you have done not less than 50 confessions in your experience. You still confirm that?
Dis korrek.
That is correct. Yebo bengishilo ukuthi engisengiwenzile ama-confessions awekho-ke ngaphansi ko-50.
When you're taking a confession in the presence of a legal practitioner, what is the role of the practitioner? Is it passive or active? The role of the attorney when you're taking a confession. Is it passive or active?
Ten opsigte van 'n konfessie behoort dit nie te wees in 'n mate dat die prokureur vir die beskuldigde vir die deposant voorsê of voorskryf wat hy moet sê nie, maar kan wel adviseer en bystaan.
With regards to a confession, it is not necessarily that the lawyer or the attorney would inform the person as to what it is to say, or in other words, lead the person into what to say, but would, advise the person and also be there or represent the person. Ngokumayelana naye-ke ummeli akusukuthi-ke uma ekhona ummeli lapho ukuthi kufanele amtshele loyo ahamba naye noma amele ukuthi yini akufanele ayisho, ukhona nje ukuthi ameluleke nokuthi-ke amxhaseke noma-ke amsupport ukuthi abe ngobukhona bakhe lapho.
Ek kan nie voort met enige bekentenis alvorens ek nie vasgestel het of beide partye teenwoordig ten opsigte van die verklaarder en die prokureur behoorlik met mekaar gekonsulteer het nie.
I do not.
En vind ek dit uiters vreemd dat
I do not proceed or I do not go ahead with taking off a statement, whether it's a confession or a statement, without confirming or making sure that both parties had properly consulted. That is now the person, the deponent, as well as the lawyer. Angiqhubekeki-ke noma ngiyi phambili-ke ngokuthi-ke ngistate-ke istatimende ngingenaso isiqiniseko sokuthi laba bantu bakhulumisene lokho kubizwa ngokuthi uconsulta ummeli kanye futhi naye-ke lona ammele.
I understand that.
She's not finished yet. It's not finished yet.
Sorry?
She wasn't finished yet. Just ask her to stop because I didn't want it to be long.
Okay, sorry, beg your pardon.
En vind ek dit vreemd dat die deposant in hierdie bekentenis enigstens andersins sou beweer.
And I find it very strange that the deponent in this case or in this instance would then now mention it or say it differently or otherwise. Futhi-ke kuyinto manje-ke engimangazayo-ke ukuthi lona-ke engangikhulumisana naye lana-ke manje akhulume okuhlukile noma akhulume enye into.
I'm glad that you mentioned the interpreter. But what I want to establish from you, the person who was going to take a confession, is that did you afford them an opportunity to consult prior to the taking of a confession?
Meneer, u het die band geluister. U weet dit is gedoen. U weet beide partye het my meegedeel dat hulle klaar gekonsulteer het.
Okay, wait, that's what. Sir, you listened to the record. You know very well that both parties informed me that they did that. Ulalelile irecord. Uyakwazi futhi ukuthi bobabilike bangitshelile ukuthi lokho bebesebekwenzile.
So die antwoord op u vraag is net kort en kragtig. Dit is gedoen.
And so the answer to your question is short and sweet. It was done. Impenduleko kumbuzo wakho umfushane nje ukuthi kwenziwa lokho noma makwenza lokho.
Ma'am, I just want us to be in the same page when I'm asking questions. For your information, that tape recording has not been accepted in this court. We can't rely on it. Do you agree? Do you know that?
Ek neem nou kennis van wat jy sê. Die staatsadvokaat het ook vir my gesê toe ek geroep is.
I'm taking note of what you say now, and the prosecutor also informed me when I was called. Ngiyakuzwa ke manje njengoba ungitshela ke ukuthi recording leyo ke asiyona ingxenye yobufakazi nomshushisi ungitshelile.
I just want to establish the presence of a legal practitioner.
Dis reeds geantwoord, meneer. Daar was een teenwoordig. Sy besonderhede is neergeskryf en sy fidelity fund sertifikaatnommer is neergeskryf. So hy behoort opspoorbaar te wees.
I've already answered the question, sir. His particulars or his details are written there, as well as a fidelity funds is also a number is also written there. So that means that he's traceable or he can be traced. Myla.
Sorry.
Myla ke imininingwane yommeli ibhaliwe lapha ya. Inamba yakhe ke ye-fidelity fund ibhaliwe okusho ukuthi ke uma efuneka angatholakala.
All that was done in the presence of an interpreter.
That's correct.
That is correct. Konke lokho kwenza utolike khona.
Between the deponent and his attorney, who initiated in the taking of a confession? Was it the deponent or his attorney?
Die verklaarder,
The deponent.
Thank you.
Umuntu ke phakathi kommeli kanye naye ke loyo owanikeza ngestatement umuntu ke owayekhuluma ke noma ke owaqala ke inkulumo kwakuyena ke lo owayinikeza ngestatement.
As I've maintained that that will be the version, but I can't repeat the version of accused number 2. Let's get into the presence of the people that were in room 2 before you took the confession. It's your evidence that you went to the other room where you collected the pro forma. You agree?
ek het uitgestap om na die senior landrus toe te gaan. Ek het haar in die gang gekry en sy het vir my die papier voorsien en ek is terug in die kantoor in.
I went out on my way to the senior magistrate. I then met her, found her in the passage. She then provided me with the documents. I then went back to the office. Ngaphuma ke ngenjongo yokuthi ngiya kuyena ke ophethe omanje noma imanje ngahlangana naye ke lapho epassage wasenginikeza ke amaphepha ngabuyela kulela hhovisi engangikulona.
So we need clarity. I think the court will need clarity in terms of the pro forma, the pro forma that you were given by Mrs. Du Plessis.
Mm-hmm.
Is it a statutory form or just a guideline?
Dit is net 'n leiding. Dit is nie 'n statutêre vorm nie, voorgeskrewe vorm nie.
It's not a prescribed form, a statutory form. It is just a guideline. Akusona ke iform ongathi iform njena ke lena anginikeza yona noma amaphepha anginikeza wona akuchazelayo ke nje noma ke ayinkomba ukuthi yini ekufanele uyenze.
For the benefit of the public, can you explain what is a statutory form?
Voorgeskrewe vorm.
It's a prescribed form. Uma ukhuluma ke nge-statutory form, iform ke leyo engathi ke iyona ke kufanele isetshenziswe.
Do you agree with me that a statutory form is more reliable than a guideline or a pro forma form that you completed on the day?
Dit mag so wees, maar ek weet nie van 'n bekentenis statutêre voorgeskrewe vorm nie.
It might be the case, but I don't know of a statutory form or a confession statutory form. Ungenzeka ke lokukhulumayo ke ukuthi ke yona ke statutory form yona ke mhlambe inikeza okuningi ke kodwa angiyazi ke leyo form leyo noma ekuyiyona ekubizwa ngokuthi statutory form uma kuhanya noma kwenziwa yona i-confession.
In essence, a statutory form will contain all the prerequisites of a particular provision, particularly section 217. Do you agree with that?
Ek weet nie wat se vorm u na verwys nie.
I don't know which form are you referring to. The form okhuluma ngayo angiyazi.
As dit 'n voorgeskrewe vorm is, dan behoort die persone wat dit opgestel het daaraan te voldoen, aan wetgewing te voldoen.
If it is a prescribed form, then it means that the people that is now, or the legislature, or the people that came up with the document, then need to, in other words, to meet those requirements.
Dit bly nog steeds die plig van die landros of die persoon wat die bekentenis afneem.
It is still the duty, but it still remains the duty of the magistrate or the person taking down the confession.
Om seker te maak dat die vraag wat gevra word sodanig is dat dit baie duidelik is dat hierdie formaliteitsvereistes aan voldoen is.
That the questions that are asked, or the questions that are contained in there, that those questions then meet the requirements or the needed requirements.
Indien die vorm wat voorgehou word. Ekskuus, ek verstaan nie die beweging wat jy maak met jou hand.
I don't understand this movement you're making with your hand.
No. Dit is, ekskuus agbare, dit is, your lordship, it is baie distracting.
It's distracting, my lord.
I believe if it's distracting, I'm sorry for that. But there's another way that I'm using my hands to rethink or to connect in terms of my reasoning. Do you understand?
Ek verstaan, maar ek sal waardeer as u dit nie doen nie, want dit is nou die eerste keer wat u dit doen vandat u my vra.
I understand, but I would request that you don't do it again because it's the first time you're doing it since you started asking me questions.
All right. Let's just do like
laat ek
this.
net teruggaan na die antwoord toe. Ten opsigte van die vorm waarop u gevra het, die Raunio vorm, dis nie 'n statutêre vorm nie. Hierdie Raunio vorm voldoen egter wel aan die bepalings wat vereis word in terme van artikel 217 en bevat genoeg inligting myns insiens om die voorvereistes vir 'n bekentenis aan te voldoen.
En ik dat alsjeblieft sin vir sin vind, want ik heb nog sekere lijnen gemis. Kan ik weer van onder gaan laten? Je zei die vorm?
Die statutêre vorm waarvan u praat, is ek onbewus van.
The statutory form that you are referring to, I'm not familiar with. Yeah.
Die betrokke vorm wat hier voor hierdie hof is, het voldoende vrae wat gevra word aan 'n deposant.
This form that is before this court, they've got enough questions or the required questions which are the requirements of this form.
Om te voldoen aan die voorvereistes soos gestel is.
As per the requirements.
Maar sou ek voorsien gewees het van 'n vorm wat nie daaraan voldoen het nie, dan sou ek dit moes neerskryf enige verdere vrae sodat ek daaraan kon voldoen.
And if I was then provided with a form that did not meet those requirements or have enough those questions, I would then have added questions to make sure that it meets the requirements.
Thank you. Can it be interpreted?
Iform ongibuza ngayo okoqala ke noma iphepha lelo ngibuza ngalo ke angilazi. Mina ke ngiphendula ngaleli eliphambi kwami ukuthi yilona ke elinale mibuzo ke eyanele noma efanele ukuthi iyona ebuzwayo. Uma kuwukuthi nganginikezwe enye ke iform kube ukuthi ke ayinayo ke imibuzo eyanele ngabe ngizokwengeza ke eminye ukwenza ke isiqiniseko sokuthi ngempela ke yonke le ekufanele ukuthi ibuziwe ikhona noma futhi yebo ngempela ibuziwe.
All right. To qualify that question or that answer, can you show me in that form a paragraph where a requirement of freely and voluntarily, a statement must be made freely and voluntarily as prescribed by section 217.
Sorry, Mr. Ngamazi. Do you have a form which has those requirements to show to the witness? Because this witness is not a layperson. She's an attorney, she's a magistrate. She knows what is section 217. And according to her, 50 confession statements in the past, she has handled them. But now, wait, Mr. Ngamazi, let's be fair to the witness. You talk about a form which you say it has the requirements which you are saying it codes 217. Show the witness that.
My Lord, if you understood me, I said, what is the difference between a statutory form and that pro forma form?
Yes, she says it's a form.
She gave a distinction. I said, according to this form, I never said I have a statutory form that prescribes this. I said, according to this pro forma form, does it constitute freely and voluntary as required by section 217? That's all what I want from her to tell me, that is it contained in that pro forma, freely and voluntarily.
Die woord ongedwonge en vrywillig, daai spesifieke bewoording verskyn nie hierin nie. Maar as u die vraag lees en u volg die vraag en u sien hoe dit gevra is en saamgestel is en dat dit wel gevra is aan die deposant, dan is dit die prerogatief of dit is die voorsittende beampte, in hierdie geval myself, wat myself vergewis het daarvan dat hierdie bekentenis wel vrywillig en ongedwonge afgelê is.
Maak het baie moeilik vir my, maak het baie moeilik. Those specific words that you are asking me about are not contained in this form. But if you look at the questions, how the questions are being asked, how the questions are being written down, and you would then myself as the magistrate, then have to satisfy myself that indeed this statement or the confession, it is indeed made freely and voluntarily. Imibuzo ke leyo ongibuza ngayo noma amagama lawo amabili ongibuza ngawo lana ke kulena iform awekho ukuthi ke ngokukhululekile okuphuma kuyena, kodwa uma ubheka imibuzo lena ke indlela ekangayo ebhalwe ngayo ebuzwa ngayo, mina ke nanjengemanje kufanele ngize nezeke ukuthi ngempela ke lokhu akhulumayo noma lokhu akushoyo kuphuma kuyena akaphoqiwe.
Een baie goeie vraag wat hier saamgestel is op bladsy 6.
One very good question that has been compiled here on page 6.
Wat in 'n neutedop u vraag antwoord is uitgesit in die vraag wat lees en ek hul aan.
Yes, for which in a nutshell answers the very same question that you are asking, and I quote,
You have now told me that you were not influenced, encouraged, assaulted, or threatened to make the statement, and that no promises were made to you in order to persuade you to do so. I wish to once again ask you to take me into your confidence and tell me if, in your opinion, anything irregular has been said or done to influence you to make this statement. I undertake to ensure that your allegations are immediately and properly followed up and attended to. En die antwoord, no, nothing of that sort. So, daar was 'n lyn van vrae wat tot op hierdie punt gekom het. In lig van die lyn van daai vrae en hierdie vraag het ek myself tevrede gestel as 'n Landros dat hierdie bekentenis wat hy van voorneme was om te maak wel vrywillig en ongedwonge gemaak sou word.
There was a line of questions that was put, and which then eventually led to the question that is the witness now just read. And as a result of that, I then, as the magistrate, satisfied myself that the statement or the confession that was made, that it was made freely and voluntarily. Kunombuzo ke lana obhaliwe athi ke iwona ke uma uphendula ke noma uphendula ke lokhu okubuzwa uyena ummeli ukuthi manje ke usungitshelile ke ukuthi akekho okugqugquzelile, akekho okushayile, akekho okusabisile ukuthi wenze sona lesi statement, nokuthi azikho izithembiso ezenziwe kuwena ukukushintsha ke umcabango ukuthi uze uzokhuluma la. Ngifisa ke manje futhi ukuthi ke wena ke ngifisa ukucela ukuthi ungethembeke futhi ke usho ukuthi ngovo lwakho ingaba khona yini ongahambanga kahle noma ongahambi kahle okushiwo kuwena noma okwenziwe kuwena ukuthi uzokwenza lesi statement. Ngiyaqinisekisa ke ukuthi insolo zakho zizothi ke zinakwe. Wase ephendula ke ethi cha akukho okukanjalo.
Thank you.
Ek wil dit net regstel. Want ek sien dit het bietjie verlore gegaan in die tolkwerk. Dit is ten opsigte van die verklaring, die bekentenis wat gemaak sou word.
Okay,
Nie wat al reeds gemaak is nie.
I just want
to
just rectify this, and I see that it got lost in translation. And just before I get on, my lord, I did request the witness. She makes very long statement, so it is possible that it might get lost. So can you hear that?
Yeah.
That in the statement that was about to be made, not already made.
Mrs. Cronje, I believe from what you were reading, it's the wording of a particular paragraph, which as a magistrate, you think it meets the requirement.
Meneer, ek het by vergewis dat hierdie verklaring, die bekentenis wat hy wou maak, vrywillig was gebaseer op die antwoorde wat hy gegee het.
Sir, I certified myself that this statement or this confession that he intended making was freely and voluntarily based on the answers that he provided me with. Ngaze neza-ke mina ukuthi istatement lesi-ke awayefisa ukusenza noma awayezosenza ukuthi wayezosenza ngokuphuma kuyena ngeyimpendulo ayenginikeza zona.
I will maintain on the wording of the paragraph. It was already a prepared wording which you read to the deponent. It's not something that is coming from the deponent to mean freely. He was answering something that has already been prepared.
Advokaat, met alle respek, dis nie die enigste vraag wat gevra is om tot daai gevolgtrekking te kom nie. Ek het die vraag geantwoord en ek volstaan by my antwoord.
Advocate, with that due respect, that is not the only question that was asked or that was put to him with regards to that. I've already provided my answer and I still maintain it. Akusiwona-ke wodwa lo mbuzo engiqeda ufunda manje owabuzwa nokuyena-ke ngokumayelana nalokho-ke impendulo sengikunikezile futhi ngimileke kuleyo mpendulo engikunika yona.
U vra vir my of ek daar in hierdie pertinente vorm die woorde basies het van het u die of is u van voorneme om hierdie verklaring vrywillig en ongedwonge te maak. Woorde tot daai effek. Hierdie vorm het dit nie. Ek is ook nie bewus van 'n statutêre vorm wat dit het.
Okay. You specifically asked me with regards to the words freely and voluntarily. And this particular form doesn't contain or have those words. And I know of no statutory form that contains those words, or those two words. Ungibuzileke mayelana nalamagama amabili. Ngokukhulekile nokuthi futhi-ke awuphoqiwe. Awekho lawo magama. Lana ayikho neform futhi engiyaziyo enawo.
And I would actually appreciate to answer me as a witness, not as a magistrate. As a witness that has been sworn in. My question is...
Mr. Mgumezo, he's a magistrate.
Yes. My lord, that cannot change.
You're saying she must answer you not as a magistrate. She is a magistrate.
She is a magistrate, yes. My lord. That cannot change.
Yeah, that's
But she must... I'll make an example of Nelson Mandela, my lord. He was a witness in the matter of Louis Late. He has never been addressed as a president of the country at that time. There must be a distinction between your position and as being sworn in as a witness.
Yeah. Hence, sorry, you may have a point.
She can easily say, advocate. I mean, she's inviting me to draw such conclusions. No. As I'm requesting the court for the protection of this witness, as the duty of the court. She must understand that where she is seated, she is a witness.
Yes.
The evidence that she's going to, I'm talking about parole evidence here. That's the oral evidence that you're giving. What you did outside is an extrinsic evidence. We are trying to follow the extrinsic evidence whether you complied with it. You are the witness to say that. Hence, if I'm saying get into the answers, the wording, let's look at paragraph 1A, for instance. Can you please read it for me?
I inform the deponent that I am a magistrate.
Thank you. Stop there. Thank you. I just want to go through the wording. What were you expecting from the deponent? If you that forms, tell the deponent that you are the magistrate. What does it say? Was it necessary for that form to say, I'm the magistrate?
Natuurlijk moet die man weet vir wie hy verskyn. Hy behoort te weet in wat omstandighede hy hom bevind, waarheen hy gevat is, voor wie hy verskyn, met wie hy praat.
Yes, of course he had to know before whom was he appearing, the circumstances under which he was or he found himself in. Bakumele ukuthi azike ukuthi uphambi kobani ukuthi futhi nesimo ke aye ngaphansi kwaso.
The introduction in the presence of an attorney, your introduction in the presence of the attorney, was that not sufficient enough for him to believe that you are a magistrate?
Meneer, op daai stadium het ek nog nie vir enige iemand gesê dat ek 'n landros is nie. Niemand sou geweet het dat ek 'n landros is nie. Ek het nie 'n toga aan nie. Ek's in siviele drag en ek's in 'n kantoor.
At that stage, I hadn't informed anyone that I was a magistrate. No one knew. I wasn't wearing my gown or my robe, and I was in my civilian clothing, and I was in an office. Ngaleso sikhathi leso ke akekho umuntu engangimtshelile ukuthi ngiyimantshi, ngangagqokile ke igown noma irobe yami yokuthi ngiyimantshi, ngigqoke nje ingubo zami ke futhi ngisehhovisi.
Hierdie man het gevra om na 'n hof toe gevat te word. Hy word in 'n kantoor ingevat met 'n persoon met siviele drag.
This gentleman requested to go to court, or this gentleman requested to be taken to court. He is then taken into an office with a person who is in civilian clothing. Umuntu lona wacela ukuthi athathwe asiwe enkantolo.
Sorry.
Usuyangena ke manje ungena kwihhovisi elinomuntu oyigqokele nje ingubo zakhe.
I'm asking you, Mrs. Cronje, do not involve or say something that is not asked. My question is, before you completed, there are particulars of the deponent on top there, which you got from either the lawyer or the deponent or the investigating officer. Do you understand?
Ja, ek verstaan wat jy sê.
Yes, I understand what you say.
My question is it, according to that paragraph 1A, was it necessary to mention that you are a magistrate?
Natuurlijk.
Does that not constitute inducement?
Nee.
No.
I'll leave it for argument. My submission and I'll put it to you that pro forma on its own, it has on a face value of it. We call it a patent defect. It has an element of inducement. If you say I'm a magistrate, that means already you sway the impulse of the deponent. Do you agree?
Nee.
No.
Thank you. I'll leave it for argument. Proceed. I'll stop you wherever I want to stop. Proceed with that paragraph. You said I'm the magistrate, comma.
And I'm not in any way involved in the investigation.
Thank you. He did not ask. You are telling him. You are making him comfortable, according to, am I right? I'm a magistrate. I'm not involved in the investigation. You are making the deponent comfortable. Is that not so?
Dit sal die effek hê.
That will have that effect. Yes. Yebo ke lokho ukuthi ngimtshela ukuthi angisona magistrate, asole ngiyi-magistrate futhi ke angisona ingxenye yophenyo. Into ke leyo engamenza ke ukuthi ke naye ke abe sena eyakhululekala.
Hy het ook 'n reg om te weet hoekom hy daar is.
He also has a right, sorry.
Waar ek inpas.
Also had a right to know as to why he was there and where do I fit in. Futhi wanelungelo lokwazi ke ukuthi ngiyubani mina ke nokuthi kungani elaphayana nokuthi mina ke ngihlanganiswa yini nalokho.
Don't get emotional, ma'am. Answer my question as I ask you. Because I followed the logic. If you say I made him comfortable, I'm satisfied. There's a next question to follow. Do you understand?
I don't know what is the basis for saying the witness is getting emotional. I think if my learned friend can just confine himself just to asking questions without taking the witness.
My Lord, when I'm asking the question from the witness and tends to say things which do not relate to my question, as it has been indicated that is a magistrate, he is actually getting out of the scope of the profession. Hence, I just want to confine the magistrate or the witness, not the magistrate, the witness on the line of questioning, because I've got the reason to stick on that paragraph 1A.
Sorry, Mr. Gomezul, I don't wish to interfere. Doesn't Section 217 speak of a magistrate who can take a confession?
It speaks about the magistrate.
Yes.
That's
and
correct.
she is approached by her senior, Mrs. Duplessis, as a magistrate to go and take a confession. It's just egregious that she happens to be a witness, but she's also a magistrate. And she, when she was told, asked or requested by Mrs. Duplessis to take a confession, she was being instructed to do or requested to do so as a magistrate, as stipulated in Section 217 of the Constitution.
Thank you.
I mean, of the Criminal Procedure Act.
May I clarify that?
Yes, okay.
The reason why I want to clarify is because we are running away from the element of inducement. A provision specifically say it must be made before the magistrate. It does not introduce the magistrate to the taking of the confession. I'm not sure if you understand,
No, I
but
don't.
I said I
I
want to
don't.
leave it for argument.
Yeah.
May I repeat what
don't.
what I was submitting before the
Yes,
Lordship?
yeah.
My Lordship is that Section 217 says it must be taken, is directing us that such a particular confession must be taken by a magistrate.
Yes.
But now, you are the magistrate, you've got the forms from Mrs. Duplessis, everyone, especially in the presence of an attorney. She should have actually introduced herself to say, I'm the attorney, I'm the magistrate who's coming to take a confession. I was told that I must come and assist in the taking of a confession. Now, my concern is about the patent defect that is on that pro forma. Because when you introduce yourself in a statement where he must freely make a statement, there's no point that she was supposed to say, I'm a magistrate.
What should she have said?
A statement,
according to you?
According to me, a statement must have been narrated immediately to say, on this particular day, this is what I've done.
No, the question, no. What would you have said? Because you say she was not supposed to have said, I am a magistrate. Now I'm just inquiring, what should she have said?
Meaning, my Lord, must I correct the pro forma according to the...
No, I'm just asking you because you're saying...
My Lord, I've never conducted a confession, and I'm not empowered by any law to do it. So I cannot think of a word that I can use when I'm taking a confession. I'm a lay person when it comes to that. A person with 50 years confession that she has made, they don't see the element of inducement in that paragraph A. Because all that the deponent was going to say is because he believed, and I'm not done with that paragraph. May I still proceed with that paragraph? Can we continue to read that paragraph, ma'am?
That I do not work with the police or any other person in this case, and that he can speak freely and without fear in my presence.
Nokuthi ke angisebenzi namaphoyisa noma ke imuphi omunye umuntu kuleli cala leli nokuthi ke angakhuluma ke ngokukhululekile angesabi ngikhona.
Thank you. The wording, you can speak. Do you agree that is not coming from the deponent?
I've never claimed that it came from him.
Angikaze ngisho ukuthi leli gama ke ukuthi ungakhuluma ukuthi libuya kuyena.
But you directed in terms of that wording, you directed the deponent to speak because You told him that you are not a police officer, you are not part of the investigation, you are a magistrate. But you further say you can. Do you understand what I'm saying?
He had a choice to speak or not to speak. It was his choice.
ukuthi ke akhulume angakhulumi kwakukuyena lokho.
So what is the next? What was the answer given by the deponent today? It's handwritten, if I'm not mistaken. After that paragraph, after paragraph 1A.
There is no answer given by the deponent at that point in time because I continued to explain to him paragraph B and C before I asked him if he understood the explanation.
Ayikho ke impendulo awayinikeza ke ngaleso sikhathi leso ke ngoba ngaqhubeka ke ngayo paragraph C B kanye no paragraph C ngaphambili kokuthi ngimbuze ke ingabe uyezwa ke lokhu engiqeda ukuchaza.
Let's hear what paragraph B says.
You also informed that if necessary, you will be afforded protection against any irregularities.
Thank you. Stop there. Thank you, ma'am. Thank you very much.
Futhi nokuthi atshelwe ke noma ke watshelwa ke ukuthi uma isidingo sikhona ke uzovikelwa noma uzonikezwa ukuvikeleka kuko nakuphi ke okungahambi kahle.
Is that not a promise? Is that not a promise? I'm asking, is that not a promise?
It may be construed as a promise that he needs to, if he feels threatened, that arrangements will be made for his protection.
I'm still there, ma'am. Don't go further than that. I asked you to
Do you want me to interpret for your client, sir?
No, I wanted to
But
stop.
she still, I need to interpret what she says. It's for your client, sir. Please allow me to. Lana ke ungasho ke ungachaza lokho ukuthi yebo isona isithembiso lesi ngokuthi uyatshelwa ke uma kuwukuthi uzizwa ngathi ke ukhona ke noma ke uyesaba ukuthi ke amalungiselelo azokwenziwa ke ukuthi avikeleke.
I ended where you said he will be protected and you considered that it amounts to a promise.
Hy is nie gesê dat hy will be protected nie. He was informed, and I quote, if necessary, he will be afforded protection against any irregularities.
Lana ke kuchazwa ke ukuthi uma noma ke uma isidingo sikhona ke uzothi aqinisekiswe ke ukuthi uyavikeleka.
Did you explain what kind of irregularities you were referring to?
Nee.
No, angishongo ke ukuthi uma ngikhuluma ngokuthi ke uma kuukuthi kukhona ke ongazange kwenziwe kahle noma kuhamba kahle ukuthi ngangishoni ngangikhuluma ngani.
Did you establish whether the deponent understood what you meant by irregularities?
Nie op daai stadium nie.
Not at that stage. Ngaleso sikhathi ke shongo ke noma ke ngiqinisekiseke ukuthi uyezwa ke noma uyazisisa yini ukuthi ngisho ukuthini uma ngikhuluma ngokungalongo ngokungenziwanga kahle noma ngokungahambanga kahle.
To put it on record, what irregularities were you referring to?
Enige iets.
Anything.
Enige beïnvloeding, enige dreigemente, enige iets wat gebeur het. Want dit kan enige iets wees wat uit sy oogpunt onreëlmatig is.
And I was referring to anything, any influence, any threats that were made, anything that could, in his eyes or in his view, could have then been an irregularity.
Dis nie aan hom verduidelik wat dit is van my kant af nie, want ek wou nie beïnvloed het daaroor nie. So as hy ongelukkig was oor enige iets, dan sou hy dit vir my gesê het.
It was not explained to him at that stage as to what irregularity is. If there was anything, then he would have informed me or told me about it.
Hy moes wel geweet het dat hy my in sy vertroue kon neem om enige probleme wat hy gehad het, enigiets wat hy beskou het as 'n onreëlmatigheid te kon noem.
He had to know that, or he knew that, or what he had to know was that he had to take me into his confidence that anything that happened or any irregularity that happened, that he had to inform me about that. Kwakuwukuthi kwakufanele azike ukuthi nokuma yini-ke eyayenzekile futhi engazange yenzeke ngendlela noma ngendlela kwakufanele ukuthi yenzeke ngayo angitshele.
Sonder dat daar enige idees in sy kop geplant word.
Without putting any ideas into his head. Ngaphandle kokuthi nje ubusufaka ke noma yini ke ekhanda lakhe noma ke umfakele nje ama ideas ekhanda lakhe.
But with regard to irregularity, we are the only one who knew about or the context or the content of irregularity. That has never been explained to the deponent. That's my point. You're the only one who knew about irregularities.
Ek was nie bewus van enige onreëlmatigheid op daardie stadium nie, meneer.
I wasn't aware of any irregularity at that stage, sir. Ngangingazi ngalutho ke ekwangabe yenzeka ke engazange yenzeke ngendlela ngaleso sikhathi leso.
Can you get back, let's get to paragraph C.
This is not a trial and I'm not hearing any charge against you.
Akusukona ke lokhu uqhula kwecala futhi ke angilalelanga angizange lana ke uzolalela icala noma amacala owethweswayo.
Right. That's very important. At the time, Ntanzi was interviewed by you, specifically on that paragraph 3, on paragraph C. Did he appear you as an accused person? Did he appear you as a suspect or any person who wanted to make a confession before you?
Ek verstaan nie u vraag nie.
I don't understand your
May I
question.
rephrase it? At that time, Ntanzi appeared before you on the 24th. Have you ascertained whether he has been charged or he was not charged or he was just an ordinary civilian who wanted to make a confession? Have you established that?
Ek het nie daai vraag in daardie opsig gevra nie, so ek was nie seker of hy al reeds aangekla was op die enigiets nie. Ek het hom hanteer asof dit 'n persoon is wat na my toe gekom het omdat hy bekentenis wou maak op wat hy ook al wou sê. Op daai stadium het ek nie eens geweet wat dit was nie.
I did not ask the question in that form or in that manner. So I wasn't aware or I didn't know as to whether he had been charged. I just took him as someone who came before me to make a confession. Ngaleso sikhathi ke ngangamazi ke noma wayesethweswe amacala noma cha ngangimthatha ke ukuthi nje umuntu oze kumina ke ofuna ke uzokhuluma.
But prior to the completion of the pro forma, did you converse or speak to the investigating officer of the case?
Ja, in sy teenwoordigheid toe wel ek het nie vir die ondersoekbeampte dis nie, ek het maar aangeneem. Toe sergeant Mogwane vir my homself bekend gestel het en vir doeleindes van die voltooiing van die vorm ek hom gevra het vir die polisiestasie en die kasnommer, sou dit nie beskikbaar gewees het nie, sou ek net daar geskryf het, not available or unknown.
Yes, in his presence, that was at the time that when I spoke to Sergeant Vusumuzi Mukhane, that's when I made inquiries with regards to the police station as well as the case number. If it wasn't there, I would then just have written not available. She also said that I wasn't aware or I didn't know whether he was the investigating officer or what. Ngakhuluma ke naye uMukhane lona ke enkathi ke ngangibuza imininingwane yalo icala ukuthi police station yipi i-case number yipi uma kuukuthi ayingekho ke ngangizobhala ke lapho ukuthi cha ayikho leyo mininingwane.
Met sekere konfessies of bekentenisse kan dit nie verskaf word nie want daar's nie 'n dossier geopen of geregistreer nie en dan skryf ek niks in daar.
With certain or certain or some confessions, it is that information is not there simply because maybe there is no docket that has no docket exists at that stage. So I would then not write that because it is not contained.
Met ander konfessies wat ek al hanteer het, is die persoon of is daar 'n dossier geopen, maar niemand is nog formeel aangekla nie. So met ander woorde, daar's 'n kasnommer, maar niemand is nog formeel op die saak aangekla nie. So ek kan al reeds die inligting hê met die konfessie, maar die persoon kan of aangekla wees of nie aangekla wees nie.
With certain confessions, it is so that there is already a docket, but no one has yet been formally charged. So there would be some information. So it's either a person has been charged or a person has not yet been formally charged. Kwamanye ke amacala noma kwezinye izitatimende uzothola ke ukuthi idocket yebo likhona ke kodwa akekho umuntu oseboshiwe.
In hierdie geval weet ek nie of hy wel al aangekla was of nie ten opsigte van die beskikbaarheid van die inligting van die dossier.
But in this particular case, I didn't know as to whether he had been charged or not with regards to the available information regarding this docket. Kodwa ke kuleli icala ke ngangazi ke ukuthi wayesethwesiwe yini noma wayesethweswe yini amacala.
Before we move on to paragraph 4, I think other paragraphs were reduced. And the other paragraph relates to a minor. But for the benefit of the public, does the taking of a confession prescribes a jurisdiction, a place where it's supposed to be taken?
Nee.
No. Ukuthathwa ke kwayo i-confession akusho ke noma ke achazi ukuthi kunendawo ethize ekufanele noma uma ngaphansi kwendawo ethize la ekufanele ukuthi ithathelwe khona.
Are you aware that the deponent was arrested at Rustenburg?
Nee.
No. Angazi ke noma angikwazi ke ukuthi wayeboshelwe eRustenburg.
Are you aware that the deponent was arrested on the 16th of June 2020?
Hy het my so meegedeel dat hy gearresteer was op die 16de Junie.
He informed me as such that he was arrested on the 16th of June. Wangitshela yena ke ukuthi waboshwa nge-16 zika June.
Let's move to paragraph 4. Sorry. My Lord, I request an adjournment. What time is it? 5 to 1. 5 to 1, yes.
We can resume at 2.
2 o'clock, okay. 2 o'clock, we return.
Hi guys. Wow, it's hot in court. Oh, hey. Very hot in court. Oh my goodness, it's very hot in court. We have seen the grilling of a magistrate now tend to be a witness. The lady is being grilled, and I have to change my thoughts there. What can we say about let's change this one. Let's say crunch. Can you say about crunch? Who is in the box? What can you say about crunch? Let me put it like that. What can you say about this lady? Cronier. She's been grilled. She's been grilled, and it's Vivian. Yeah, Vivian. Vivian Krunye. What can you say about this one? But I'm telling you guys, I've seen professionalism in the way Mgomezulu is actually doing his things here. I'm impressed. Definitely, I am impressed. I used to be more fascinated and interested in Mshololo's approach of things, but now I'm seeing now that wow, at least now they can work together very well. They can work together very well with this advocate. Definitely, they can work together very, very well with this advocate, because I know definitely that it's a serious thing. It's a serious thing. Wow, but it's interesting. Komezulu isn't even scared of this judge. That is what Nduduzi is saying. Why are you saying Komezulu is hot? Yo, no, definitely. I have seen it, and I respect this man. Definitely, I respect this man. Definitely, I respect him, and I love his approach and the way he does things. Pro Zombo, you're saying big up to Mgomezulu. Yes, this is interesting. And Mgomezulu is making sure he doesn't leave any stones unturned. Wow. Not like you're saying it is very interesting there. Yeah, he's going step by step. He's not in a hurry. He wants to make sure that everything. Now, there's something that is interesting. Where the person was arrested and where this person made a confession, the location is different. Automatically, if the location is different, it actually affects his what do they call it? Jurisdiction. What do you call it? Jurisdiction, right? Jurisdiction. So according to that, according to that, you discover that now this is so interesting, because the person was arrested in another place and now is coming in and putting a confession in another place, and this lady is exposing herself because she was asked, were you aware of what had happened to this guy? Were you aware? There were certain things that she was not even aware of. Yeah. No, she's not a judge, Simba. She's not a judge. She's a magistrate. She's a magistrate, actually. She's a magistrate. You're saying Komezulu is going word by word and say stop. The magistrate is now confused. Exactly. No, he's actually, he's doing his work thoroughly there. I love it. He's doing it thoroughly there. You can send in your voice note in the interim. I can play it, or we can just go for lunch. When is Kelly testifying? I think very soon. Very soon. I don't know, because we are at witness 90 something. We are in big numbers. I think, I don't know, because according to Kelly's lawyer, she's not supposed to come to court. Kenneth, you're saying this magistrate will use sleeping medicine, and Judge Rata meet his size today. I definitely. I want to check the I want to check something as well, because there is some things that we need to verify, because if you look at the story, the way it is now, there's a lot of gaps. There's a lot of things that needs to be attended to. There's a lot of things that needs to be attended to. I need to read the other comments for others as well. Let me see. I need to read the comments of others. Let me see. But I don't know, what's your view, guys? What's your view over this? What's your take over this? What's your view? What's your own view over this? Just talk to me. What is your view over this? Just let me know, so that we can actually be all on the same line. just talk to me. Or let's go for lunch, isn't it? Let's go for lunch and then we'll come back and let's go for lunch. Let me see. I want to see something. We can actually. I was actually checking. We'll come back and I was actually checking something. Okay, I was actually checking something quickly. Okay, here we are. How come is she not supposed to come to court? Yes, according to the judge, to a lawyer, she's not supposed to come. Tabo, you're saying this is a high-profile case, and I am of a view that senior counsel were the one to deal with this matter from the onset. I'm impressed by Nkomezulu. He's exposing a lot of. There's a lot of errors. There's a lot of errors, guys. There's a lot of mistakes. There's a lot of mistakes that actually happened. There's a lot of mistakes. Too much mistakes here. There's too much mistakes. Tando Nkos, you're saying Nkomezulu is on point. Shai, you're saying Nkomezulu is a fighter. He must join the EFF. We need advocate like him come 2024 when EFF takes over power from fighter. Kudumela Shai, Mpumalanga province, Sekunda. All right. I'm impressed with Nkomezulu. That's Kinadisha. Not all they're saying Vivi. Got the broad envelope. Say Vivi got a broad envelope. Vivi got a brown envelope. Now she's confused now because yeah. And one thing which I like is have you noticed that there are some people who think that if something is coming from a white guy, I'm not against them, but if something is coming from a white person, they authenticate it, they make it to be valid. But now you can see now there's a lot of fabrication and there's a lot of things that is happening here. Muketele is saying, Kumalo, you're saying exactly, Scone. Kinna Disha, you're saying, I like how Nkomezulu is taking his point, questioning without being emotional. That's him. He's calm, very, very, very calm. Nkola, you're saying, forward Nkomezulu, forward. Strong defender. Boso, Bax, Ntunzi are saying, strong defender. For now, Orlando Pirates is winning this game versus Gininda. Team Gininda is losing, guys. Team Gininda is losing. Team Gininda is losing. And I wonder why did she actually take this? Baltina, I agree with you. Mohadi, Baltina, I agree with him. Nkomezulu is a beast. He's moving, definitely he's moving. I used to actually, I thought my crush, Shololo is the one who can move things, but now I can now see now, oh, the combination is now serious, it's now intense. This one, Munisi and Shololo, I'm telling you, not like they're saying, oh, of which Odot, but guys, I've never seen something. Let's go for lunch, guys. Let's go for lunch. Let's go for lunch, and then we come back, go and drink some water, eat some lunch, and then we come back here and see how we continue. Suddenly are saying Jesus must come back. All right, guys. I will leave you now. But I'm there. I'm just waiting for some voice. Ketile Kumbalo is saying, please tell my husband I love him so much. I'm going to phone them now. Because I need to speak to Baloy and tell him, Baloy, please, if you are a man enough, please just come out of the court nicely, diplomatically, silently. Pacman, you're saying, wow. Tabo, you're saying, lastly, my brother, one need to visit agenda page. They will clearly understand accused are forced using plastic chop and choker to make statements without their consent. Yeah, that's what we heard. If you look at the accused family, they will tell you that no, they were beaten up and they were even promised money. there was a lot that actually happened. Albakwe is saying he has solved Rata for us today. Definitely. Rata is put in his place. He's in his place, guys. Not translate saying we are fasting today until court closes. All right. It depends on which type of fasting you're talking about. Which one are you talking about? Which one are you talking about? Fasting is indifferent. Gomezulu must tell us when he ran out of petrol to attend the court. Will make a plan. He must never ever miss a court date. Definitely. Kinadesh, I agree with you. Kinadisha, I agree with you 100%. 100%. Kolekile is saying the interpreter got a little bigger for his shoes there for a moment. I saw it. He wanted to be a bit aggressive and those things. Ketile Kumali is saying, don't worry, my husband is sorted with me. Okay, not translating. We are fasting food-wise, guys. We are fasting food-wise. I understand. So no liquids, no food, nothing. Mm-hmm. The interpreter that time, I saw that he wanted to be. He wanted to be big-headed. He wanted to do something because I don't know why he was doing like that. I don't know why he wanted to. I don't know what made him to be angry. From Norway, he wanted to be angry and he wanted to show his. But Mgomezulu was spitting fire. Muzukisi, I agree with you. Beauty is saying, Mr. Mgomezulu and Miss Mishololo, they are moving forward by fire. Madela, you're saying, for the benefit of the people, we can go on lunch. Sitle, there is a request that we are on fasting today until the court ends. So there is no break for us because advocate Bishop Nontlantla has said we are on a fasting, so it's declared fasting today. So food-wise, no one is taking food for now. For now, we are here, Sizonke. So Beauty, you're saying Mr. Mgomezulu and Miss Mishololo, they are moving. Okay, that's Beauty. I read that one. So guys, let's play this one for the family of the accused. Let's hear to those, especially to those who did not see this one. Please pass my greetings to Kronye. Kronye, tell her she must never ever mess with Mgomezulu. I don't think she will repeat this mistake. She was told that no, when you are there, you are not a magistrate. When you are there, you are a witness. So the judge was now saying, but now she's a magistrate. Yes, we can't change that, but as long as she's in that box, as long as she's there, no, we rule there. This one of her, she rules at a court, not in our court. This one is ours. Yeah, we claim it by fire, by force. Yeah, claim it by fire, by force. All right, let's hear this. There's a clip that I was playing for you that time from Longetwala. There's something that let's play that one first before I got to this family video. There's this one. We need to those who did not hear it. I want you to hear this. I want you to hear this clip.
Our phones. I went in for questioning and everything.
Which phones?
Our personal cell phones.
Oh, okay.
Yes, just
they hadn't taken them from you.
They took them from us, and then
the criminals, I mean.
No.
Okay.
No. They couldn't take my phone because I ran out. I had my phone in my pocket, so they didn't take my phone.
Mm-hmm.
Firstly, was asked nicely, wait, did they take your phones? He agreed, yes, they took our phones. So the lady asked, Mashaba asked, did they take all your phones? Say, no, I was having my phone with me. You see, this thing, icon.
Phones. I went in for questioning and everything.
Which phones?
our personal cell phones.
Oh, okay.
Yes, just
they hadn't taken them from you.
They took them from us, and then
The criminals, I mean.
No.
Okay.
They couldn't take my phone because I ran out. I had my phone in my pocket, so they didn't take my phone.
It's where you're at. It's 8 minutes past 4 o'clock. Welcome. It's The Drive with Mo Flava and Masichaba and Ndlovu. And we welcome you to The Drive Long. Thank you so much for responding to our invitation.
I'm actually saddened that my own people can do this to me, you know. I mean, it was a robbery gone wrong, you know. I was even the coward of the day because I actually ran out as those gunmen actually came in and requested phones and money from us. I was actually the first to stand up to try and protect everyone. I wanted to go get help, but it was later. Neighbors and everyone was sleeping. I didn't even have my phone because I left it at
The neighbors were sleeping. He said that the neighbors were sleeping. He couldn't actually call anyone because the neighbors were sleeping, which contradicts with what Sandy said. So the neighbors were sleeping. He could not call anyone, and he could not even make a call to the police because his phone was left in the house. In which in the beginning he was saying, I was with my phone in my pocket. I was with my phone in my pocket.
I wanted to go get help, but it was later. Neighbors and everyone was sleeping. I didn't even have my phone because I left it at the house, so I couldn't call the cops. A fight broke loose inside because obviously Senzo was protecting Kelly because the guys were handling Kelly, and then that's when the guys actually released the gunshot, and then that's when the bullet killed Senzo. Our phones.
So this is Twala's longer Twala's version. Nonhlanhla is saying I love the Giaco grilling part. Mgomezulu cleared that aspect for us. Now we know who is this Giaco person is. Yeah, that person. That's why he cleared that this person went to the magistrate without a proper legal representation. My goodness. Wow. Wow. To me, all this time I thought it was a she, but I'm hearing now he's a he. I have to check again. Because, but I think I saw a place where this guy was arrested for something else. The guy was arrested for something else. Interesting, guys. Interesting. I don't know, but this is very interesting. Temba is saying in Kosa, they say you hide a stick from us. Mr. Ramuse Sepel, you made South Africa proud. This is the equality before the law. Definitely. There's quite an interesting turn and a twist of things here. There's quite a twist and turn of things here. So let's just continue to believe that it will continue like this, because hey, we really want justice to be served. Definitely. Let me play this for you quickly to those who did not see what the families were saying.
It was a blow, as these families say they had not had contact with Advocate Malisa Latefu, who had been representing the pair and 4 others.
Kulungile. uNkulunkulu usabele wasipho kubi nathi abanye abantu ebapho kuhle. Akekho umuntu ozalela ukuthi angazuzi ngengane yakhe. Nathi sibheke okuthile ngomzakhulelwa, njengoba ngangithi umzakhulelwa ngangilandela ukuzaleka kwami mina uqobo. Ngagcina ngithi-ke namhlanje ngizele umzakhulelwa. Umzakhulelwa uye yedwa, indodana yami ekhona la ekhaya engethembele kuyo. Ineyingane la igcekeni iganiwe. Ithemba lami benginalo kutefa ukuthi ngelinye ilanga ingane yami izophuma kule ndawo ekuyona. Ngendlela ebengimbona ekhuluma ngayo, nangendlela ebengazi ngayo nami. Ngoba bengazi ukuthi umzakhulela kwasiya umbulali kaMeyiwa.
Not far from the Sibiya home is the Ntanzi homestead, the family of the youngest of all the accused. 30-year-old Bongani Ntanzi is also referred to as accused number 2. They tell us he has been the breadwinner of their family, providing for 10 people, including his 9-year-old child. Because Bongani was the sole breadwinner, his absence also meant there was no money to even travel to Gauteng, where he is currently incarcerated. They say he got himself a lawyer, as none of them could afford those legal services. All they could do is watch the trial on television, especially on behalf of their mother, who can't bring herself to watch the proceedings. Every time he enters the dock, she leaves the house to get an update later. It was a shock to them when Advocate Malisela Defo dropped the news of his withdrawal.
Isathatha naye izinto ngendlela yakhe afuna athathe ngayo ukuze egcine ebamele kanti bese sithi mhlawumbe sithembile emephethelweni for ukuthi ngwanakho usebatholakele ngendlela engibuka ngayo lo mmeli besebenzile ngoba kuzovele konke lokhu nje nokuthi basolwa yilaba abenzi baletwe yilaba kusithemba yena ngendlela besimbone ekhuluma ngakhona nandlela aphenye ngayo kuze igcine sekubuvela ngale ndlela siyambonga yena ummeli lapha khona ngoba konke lokhu nje kade lokhu sikhuthene sisangene.
In an unexpected but not surprising turn, Defo wrote to the state informing it that he had resolved issues with what he terms relevant stakeholders and will therefore continue representing accused number 1 to 4. But there's a catch. He has listed a number of demands that he wants adhered to before he and his clients can show up in court on Tuesday. Those include a separation of trial between his clients and accused number 5. He also wants a new judge appointed in the matter and the prosecutor, Advocate Baloyi, removed from the case. Defo says he also wants Police Minister Begicele to be removed from his position and be investigated. In the same statement, he reveals a fresh, new reason why he withdrew from the matter. Without substantiating, Defo accused Judge Maumela of witchcraft, citing it as the main reason why he decided to leave the case. Although at the time of this interview these families did not reveal this information, they agreed that he was subjected to unfair treatment in court. Muzikau Khalelwa and Bongani are said to have made confessions, but according to Advocate Malisela Defo, these were obtained under duress. He claimed his clients were severely assaulted through the use of what he called apartheid tactics to get them to confess. He called on the court to hear a special plea for a trial within a trial. His plea fell flat after Judge Maumela ruled that he failed to follow proper court procedure. Defo had also not filed papers as required for a court application, but addressed the court from the bar instead. To top it all, the state had not submitted these alleged confessions to the court or indicated that they would depend on them. The families believe that their children are innocent.
Umfana lo waboshwa konje kwakumhla kabani mama? Mhla ka 30 June. Mhla ka 30 June. Mhla ka 30 May yes. Waboshwa mhla ka 30 May inyanga yonke singamazi ukuthi ukuphi. Kwazothi ngo June. Angisazi ukuthi kwakumhla kabani bafika naye la ekhaya. Ma befika naye la uyangitshela ke ngoba bathi angiye kuye ngiyokhuluma naye. Uthi baba ngiboshiwe. Ngendlela ebengishaywa ngayo bengibulawa futhi bengitshela bethi bazongibulala njengomnyu khona abambulala eFosrolas amaphoyisa amdubula bathiwa yiba bambulala nami ke bazongibulala bemvalele ehlathini laba bemvalele khona ngendlela ngagcina ngivuma bethi angivumi ukuthi ngabulala Meyiwa kodwa okokuqala babethi akacindezele laba bazomnikeza 100,000 wathi ngalile baba ngoba ngiyazi into engingayivumela engathi ngizothi laba ngibacindezela ngani ngazini ngangikuphi bathi-ke bathi bazongifaka ecaleni sebengifakile-ke ngigcine ngivuma istatement abangibhalise sona ngizivumile angivumi ngoba ngikwenzile ngivume ngoba ngivikela impilo.
Ntanzi's family also claimed that the same happened to their son.
Wathenjiswa 3 million babemshaya before uthe vumele icala umbhaxa nje umfaka nasefrijini sazi efrijini bafaka ngoba bemfaka belivulile noma babecimile ngazi-ke la kude khona awuthole lokuthi wafaka efrijini
afake efrijini yakho pheje
noma kusanoma bayesejele noma kude khona babembombile bona noma bengamfakile esitokisini kodwa babembambile babembambe khona.
Sibiya's father says he raised the issue at a magistrate's court where he had been appearing for a different matter and was subsequently moved to a different prison. While the state had not submitted these confessions as evidence or indicated that it would rely on them, it has remained tight-lipped on its strategy to nab the accused. The confessions form part of Defoe's representations to the NDPP in a bid to have the matter withdrawn. For some members of the Meyiwa family, these developments were expected. They believe the 5 men standing trial are innocent. They say a plan is on the cards for this docket if the National Prosecuting Authority decides not to prosecute.
Getting private prosecution.
Oh, so that's your next step, private prosecution.
Private prosecution.
Meyiwa says his brother's case has been at most marred by corruption.
I-leading investigator kwa-case 375, 635, 636 yantshontsha istatement esasodala ukuthi kuboshwe umuntu wayelapha endlini. Yasitshontsha leso statement ingakho kwavulwa lo case 375. Labantu babawu-5 baboshwele ukuthi kuzanywe ukuthi babefuna yona ukuthi le case ivalwe kuthiwa ubufakazi mhlawumbe abukho noma vele sebethenge nama-witnesses kuboshwe labafana aba-5 ivale ingabe savela leli bashaye phansi-ke manje nali selivelile.
On the 26th of October in 2020, Police Minister Begicele visited the Meyiwa family to update them following the announcement that 5 suspects had been arrested.
Mfethu wadidisa umanje wadidisa wamtshela ngokheli ukuthi ukheli yena wamtshela nje ngokheli ukuthi yena uzoboshwa nalabantu abawu-5 ibona okuyibona suspects. Umuntu okhuluma ngalabo abantu abawu-5 vele ngibona nje ukhuluma into engekho wayezodlala nje ngo-lady ezokhuluma into engekho ngoba into engixakayo sasikhuluma naye uyazi ngoba yabo lama investigators at 375 bekade reporter kuyena uminister ucele obuthelezi benomakhuba bereporter kuminister ucele bese ukuthi laba abanye bereporter ku Khehla Sithole. In fact laba kwakufanele nabo laba ngaba reporter ku Khehla Sithole ngezathu zokuthi khona ubugebengu obenzakalayo kwacaca ukuthi no aba-reporter ku-minister ngoba laphaya into ekhulunywa lapha akuyona le fanele iveze iqiniso cover up yodwa ehlanganiswe lapha base ba-reporter ku-minister uminister besike sikhulume ngisho naye efonini esho ukuthi no uyazi naye ukuthi le nto eyenziwa yilaba abangala ayikho nabo abantu abakhuluma into eyiyona.
So nimbuzile manibona ukheli angavele ecourt ukuthi ukheli kwenzakaleni?
No, akaze simbuza ngavele ngabona ngayibonela nje the day ekhuluma indaba yokuthi in fact ngabona before akhulume leyo nto khona izinto engase ngiyibona angifuna ukusho ukuthi yini kodwa khona izinto ayikhuluma ngabothi I know sekhona into influence wrong bese ngibona vele ukuthi use cishe mhlawumbe khona into abamsabise ngayo noma khona amacala abawaziwe laba bantu abangala laba bakhe 63 ngoba bagudike lapha ekubophisena abantu nokuthi nje mhlambe khona amacala abawaziwe abamsabise ukuthi bazowaveza.
The South African Police Service says it cannot comment on matters that are still in court.
As you are well aware, the case is currently in court and sub judice. Any issues pertaining to the case must be directed to the NPA and the court itself. Evidence will be dealt with in that forum, and as such, the SAPS cannot comment on cases that are in court.
The side of the Meyiwa family that believes that these are the suspects says it has no intentions to comment on the information by Sfiso. It says the onus is on the state to prove that the confessions and or admissions made by the accused were made freely and voluntarily without undue influence.
It is said ukuthi we have spoken to General Kehlas what is the head of the investigation, who General Mfazi will update us if anything happens or if there is any breakthrough in the case. So, and today we wake up to the news that the firearm has been found. And we're just hearing it from the media. In the media, we've already knew it maybe a month ago or 2 months ago. There was someone who was claiming she was a sense of shock. We don't know. Only the police, Lawa Asabenzifana, no general told or Azil. Because you must remember there are two teams in this investigation. There's a team that there are two teams of who are supposed to be working together, but they are not working together. So the team, obviously, like Chole, they know which is someone who has been claiming which he was there. But we were told that when there's a time for arrest, there will be people who are claiming which they were there. Yes, we all know which there was no one who entered the room. Amaphoyisa njengamanje kumele engabe abopha uLongwethwala for killing uSenzo. Senzo was shot by Ulongwethwala. There was no one who entered the house. Bese ebopha all these police who have defeated the ends of justice. Senzo was shot by Ulongwethwala. A call was made by Tumelo. The first call when Senzo was shot was Tumelo, a boyfriend Kazandi, of which he didn't know by name, had shot Senzo, and then a phone was dropped. At the background, Ukeli, she was crying, and that information was given to the SAPS. Why they do not want to arrest Ulongwethwala, I do not know. For me and my family, it is up to them. It's long overdue. We've said to the police several times, and the good police who are in the side of justice have said it. There was no one who entered the house. Yes, who are working on this case. Even who advocate Chauke in Gauteng, he confirmed it. According to the information that was given to him, there is no one. I had a live recording of Advocate Chauke saying, according to him as an advocate, experienced advocate, there was no one who entered the house.
Important to start off with reflecting exactly that. The family has always had a cry to say that police and investigating authorities never say anything to them. Over the last 6 or 7 years since Senzo was killed, information has been coming to them through the media. And in fact, I remember quite distinctly Senzo Meyiwa, Senzo's mother, saying that another issue that they told Begicela about when he went to go visit the family last year is the fact that there were always different police investigators coming to give them information, which they believed was also causing a significant delay in the matter being actually finalized. Now, subsequent to Cele's visit, he was there sometime last year, late last year, around this time actually. In July, Cele had established a special unit that would be looking into this particular matter of Senzo Meyiwa's killing. And of course, you'll remember that Cele came under a lot of fire because he gave deadlines that he never met. He initially said that by Christmas, that was Christmas in 2018, there would be feedback, and that didn't happen. Then he promised by Easter last year in 2019 that there'd be feedback. There was still no feedback. And in actual fact, when Cele had gone last year, it was because Sam Meyiwa, Senzo's father, had also passed away. So he was there to pay his condolences to the Meyiwa family. Now, that's one of the issues. But just like Siyabonga Mia was saying today, Senzo's mother also told us that they know exactly who killed Senzo Meyiwa, and in fact, she was of the belief that the same people who killed Senzo were also responsible for her husband's death. Let's take a listen into what she had said at the time.
Noma ngoba ungaqhamuka azosiza ngani ukube bathi bebulala uSenzo bazoza la ekhaya bathi simbulala uSenzo ubulayo ngephutha bazoza la ekhaya bathi sizoxolisa la ekhaya kubafika eqaleni ngasathi bebulala uSenzo akaze kufike umuntu la ekhaya ezobika ukuthi uSenzo ubulayo ubani abaze bafike kuba bafika isikhathi lokuqala bathi uSenzo ufike ngephutha bese besidadake bakhokhela amaphoyisa abasikhokheli thina babhizi bakhokhela amaphoyisa iqiniso lilapho nje bakhokhela amaphoyisa wasikhokheli thina babulala uSenzo kuyaziwa khona mangasalala ebusuku abangalala ebusuku hayi kahleni makithi kahleni abafike namhlanje mangibulala bebe ngibulala babulala ingane kaSenzo sife bese beyidleleke imali.
Well, Tami, as you can see, they are very emotional in Ntomfuthi Meyiwa, and one of the biggest cries actually was the fact that the family is not being taken care of. And the fact that she's raising one of Senzo's daughters, who is a teenager in high school, and her biggest cry was that Senzo's killers are out there. She says that these people have money. Now we heard from Siyabonga, he's named Longwe Twala. I mean, that's something that's a name that's been on the rumor mill for the longest time. But the News 24 report, I must actually just reflect this, Tami. The News 24 report says that the weapon that was used to kill Senzo Meyiwa has been linked to a man who's currently serving a jail term sentence in a Johannesburg prison, and that he was also responsible for the killing of an Alexandra taxi boss. So it's very interesting to see whether or not then who else this evidence will be linked to, and whether or not then it will still be linked to Longwe Twala, as the long-standing belief has been that, of course, he is responsible for the death of Senzo. I think for many people, South Africans at large, you know, Orlando Pirates supporters and those who love Senzo Meyiwa, the biggest question has always been, why has it taken the police so long to get to the bottom of this when there were so many witnesses in the house? And you'll even remember that the family reached out to AfriForum to take this matter up prosecutorially. So we know that the police had concluded their investigations, but it was up to the NPA or the likes of AfriForum taking up the matter and investigating it further. So now it seems as though the NPA, according to the News 24 report, is actually going to make a final determination on what to do with this matter. But just to go back to the family, Tami, because it's been 6 or 7 long, painful years, because they believe they know who is responsible. And again, they've emphasized that police haven't been forthcoming with information. Let's hear what the mom said at the time as well.
So it's going to bafike la sikhulumisana ngabe leqala liphelile ngabe mhlambe noma lo waboshwa wagwetshwa basinikeze basize siphile siqhubeke nempilo njengabo nje bephila kahle baphila kahle bona thina siphile kahle siyasokola.
I'm under oath right now. There's not much to say, or there's not much that I can say right now.
Sure.
But obviously, this is a democratic country. I was just merely exercising my rights. And I feel that that is why even the court took about 2 days or so, you know? And they found that it was actually within my rights to actually exercise that. And I don't know why now is it a hoo-ha that we exercise my rights since this is a democratic country. The thing is, this has happened 8 years ago. People had so much to say. They had their own opinions, and of which obviously they are entitled to that. And there's not much I can say, you know. My family and I have been, there's no platform that we've not been to trying to explain exactly what happened, but it seems like they choose what to listen to and they make their own decision. I'm under oath.
Untanzi lapho kusho ukuthi ubuze indoda ngami ngiyaqala ngisho ukubona nje konje imigamo bami isibongo ubani achazeke nje hayi no ukuthi ngaboshwa la kanje achazeke nje i-story sakhe achazeke na ukuthi yena wethengiswa u3 million ukuthi uma ngabe ngafike ecourt ame ngathi kusho ukuthi abantu abenza lokhu yithi manje sebefuna abanye abantu asebezobhala ngabo into enjengedocument kuphela.
They're not the perpetrators. I think this will be a big slap in the face. Because then they'll be like, what the hell have the police been doing?
Bayangibopha bayangithatha lapha esitratini engimkhona lamajika bangena up until ngize ngivume nami ngithi hayi ngendlela bangishaya ngawo vele bangishaya ukuthi bayangibulala noma yini sengingafanele ngani so ngize ngivume ngithi hayi kulungile sakwenza lokho mina ngithi mina ngibona malume cause malume uzokwazi abazali bami ukuthi ngikuphi ngiyaphi noma ngiphi uze ukuthi bona no awufuni ni wena ukuyobona abazali bakho 99 ngibazi hayi ngiyababuza amadoda yindaba sizowenzani ecourt sethi nabayi asazi untanzi lapho kusho ukuthi ubuze indoda ngami ngiyaqala ngisho ukubona nje konje imigamo bami isibongo ubani achazeke nje hayi no ukuthi ngaboshwa la kanje achazeke nje i-story sakhe achazeke na ukuthi yena wethengiswa u3 million ukuthi uma ngabe ngafike ecourt ame ngathi kusho ukuthi abantu abenza lokhu yithi manje sebefuna abanye abantu asebezobhala ngabo into enjengedocument kuphela.
They're not the perpetrators. I think this will be a big slap in the face. Because then they'll be like, what the hell have the police been doing?
Bayangibopha bayangithatha lapha esitratini engimkhona lamajika bangena up until ngize ngivume nami.
I'm under oath right now. There's not much to say, or there's not much that I can say right now.
Sure.
But obviously, this is a democratic country. I was just merely exercising my rights. And I feel that that is why even the court took about 2 days or so, you know? And they found that it was actually within my rights to actually exercise that. And I don't know why now is it a hoo-ha that we exercise my rights since this is a democratic country.
Who has already been charged. Am I right?
That's correct.
Umsolo noma ke umangalela umuntu osetheswe amaqala vele.
Before he is charged, he is a suspect. Am I right?
That's correct.
Ngaphambilini kokuthi ke abe uyacharge noma uthweswa amaqala oba umsolwa.
You were approached with a person. Eventually, you took a confession and completed a pro forma with an incomplete information that the person in front of you is not either a suspect nor an accused. Is that so?
That's correct.
kunjalo ke ukuthi inkathi ke ngigcwalisa le form bengazi noma ukuthi ngumsolwa umuntu oseboshiwe osetheswa amacala noma cha.
In other words, the accused person or the deponent, I'll refer him as a deponent. In your own opinion, was it irregular for you to take a confession on a person that you have not satisfied yourself that he has been touched?
Nee.
No. Kwangekho ke okungekho noma ungahambi kahle ukuthi ngithathe noma ke i-confession lena kumuntu engingamazi ke noma sethweswa amacala noma cha noma uboshiwe noma cha.
And it is your evidence that you have explained the constitutional right of the deponent. Is that so?
Nou wat se konstitusionele reg het jy verwys?
Which constitutional right are you referring to?
Okay, a right to remain silent. E.g., a right to remain silent. A right not to self-incriminate.
That is correct.
Sorry?
Ek het vir hom gesê dat hy nie, as ek net na my dokument kan verwys,
If I can just give me a moment just to refer to my document.
Dis korrek, bladsy 4, paragraaf 6.
That's correct. Page 4, paragraph 6.
Kan ek hom lees?
Can I read it?
I'll tell you to read. Just a moment, ma'am. Just a second, I'm trying to peruse that paragraph. All right. Can you please read it?
Paragraaf 6. En ek hul aan. I informed the deponent that he has the right to remain silent and that nobody can force him to make a statement, and that if he chooses to make a statement, nobody can force him to divulge any self-incriminating evidence or information rather. And his answer was, I understood.
Lana ke kubhalwe ukuthi ngase ngimtshela ke ukuthi unelungelo lokuthi angathula angasho lutho nokuthi akekho umuntu ongamphoqa ukuthi enze istatement nokuthi uma kuukuthi ukhetha ukwenza istatement leso akekho umuntu ongamphoqa ukuthi ke asho noma yini engamhlanganisa naye ke necala ke noma ukwenziwa ke kobulelesi nga impendulo yakhe yathi ngiyezwa.
Ek het voortgegaan in dieselfde paragraaf en vir hom gevra en ek hul aan, do you wish to remain silent or do you wish to continue to make a statement? En sy antwoord was, I want to continue to make a statement.
I then proceed, and then the next question is the one where it says, do you wish to remain, oh sorry, it's in English. Uyafisa yini noma uyafuna yini ukuthula ungasho lutho noma ufisa ukuqhubeka ukuthi wenze istatement? Impendulo yakhe yase ithi ke ngiyafuna ngokuqhubeka ngokwenza istatement.
So, may I approach my colleague?
Yes.
My question is, when you explained that right, you explained the right that is provided by Section 35 of the Constitution. Is that correct?
That's correct.
That is correct. Yebo kuyiqiniso ke uma bengichaza lokho okubhaliwe ke noma okhona kuye ke uSection 35.
Can you please read Section 35, especially Section 35(1). Or sorry, let me just be specific. Can you please read Section 35 in conjunction with the rights that you have explained, that you have already given to the court? That are the rights that you explain to the
Moet ek die hele section 35
Nee,
lees?
just the right, section 35, and specifically to the provision that relates to remain silent.
Artikel 35 sub 1A, na aanleiding van die boekie wat nou in my oorhandig is van die konstitusie, lees as volg in Engels, en ek haal aan: Everyone who is arrested for allegedly committing an offence has the right to remain silent. Dit is in subartikel A.
That's in subsection A. The witness says she's quoting from the booklet that has just been provided to her.
Everyone.
Should I proceed?
Just a second, ma'am. I'll tell you to proceed. And the other one that relates to self-incrimination.
Artikel 35(1) subartikel B gaan voort en bepaal die volgende. En ek haal aan: to be informed promptly, Roman 1, of the right to remain silent, and 2, of the consequence of not remaining silent.
Thank you.
Lana ke ikhuluma ke ukuthi ke ilungelo ke lokuthi ungasho lutho nokuthi futhi imiphumela yokuthi noma ke ukhulumeke ukuthi ingaba yini uyena ke lowo usection 35.
Was it not important to inform him that he is still presumed innocent until proven guilty? Was it not necessary to?
Ek sien nie die nodigheid en het nie die nodigheid gesien hoekom dit in 'n bekentenis pertinent aan hom genoem moet word nie.
I don't see. Sorry. I don't see, or it didn't see the necessity or the need in a confession to say or to mention that to him. Ja, kan maar voortgaan.
Hy was verteenwoordig gewees deur 'n regsverteenwoordiger ook.
He was also represented by a legal representative. Ukuthi ke ngimtshele ke ukuthi umuntu ke kufanele futhi ke noma ke umuntu ngimtshele lokho angisibonanga isidingo ngoba ke ebe nommeli aye naye ngalelo langa owayekhona futhi lapho.
Dis 'n beginsel van ons reg dat alle persone beskou word as onskuldig totdat hulle in 'n strafhof bo redelike twyfel as skuldig bevind word.
It is a principle of our law that each and every person be presumed to be innocent until proven guilty by a court of law. Kuwumthetho ke okhona lana ke eNingizimu Afrika ukuthi ke nawubani ke ovela enkantolo ukuthi loyo muntu ke uthathwa njengomuntu ongenacala kuze kufike ufinyeleleke kwisigaba la khona ke kuthiwa ke uselahliwe amacala.
En het ek in lig daarvan dat dit nie 'n verhoor was, nie nodig geag om hom as sodanig in te lig.
And then as a result of me then considering that not to be a trial, then did not see the need to inform him as such. Ngenxa yokuthi ke kwakungaqhulwa cala ke ngalelo langa angizange ke ngisibone isidingo sokuthi ngimtshele lokho ke ukuthi cha bona ke manje njengoba ulapha phambi kwami ke umsulwa ke kuze kube yisikhathi ke noma isigaba la khona ke inkantolo isithi ke wena ulahliwe amacala.
Hy is op geen stadium van die verrigtinge ten opsigte van die bepaling of hy voor my is vir hierdie bekentenis vrywillig, ongedwonge, sober en nugter by sy volle positiewe en verstand hanteer as 'n persoon wat skuldig is wat sy onskuld moet bewys.
At no stage whilst he was then before me and as he was that informed that he would be doing this freely, voluntarily, that he was in his sound and his sober senses. At no he was at no stage at that time then considered by myself as someone who had to prove his guilt to me.
May I just put it to you as a person who has a legal expertise that you were under a legal duty or obligation to explain the right to be presumed innocent until proven guilty, because the effect of taking a confession does not conclude his conviction. What is your comment?
opinie?
I take note of the opinion.
Thank you. Let's proceed. Can you please assist me to read a provision relating to 48 hours? I think it's 35.3 if I'm not mistaken.
In artikel 35 subartikel 1 D Romeinse 1, to be brought before court as soon as reasonable possible, but not later than the 48 hours after the arrest. Unquote.
Lana-ke sichazwa-ke noma ufunda lana-ke ingxenye la ekhuluma khona-ke ngesikhathi umuntu akufanele-ke ayovela ngaso enkantolo ngaphambi emuva kokuthi eboshiwe.
The deponent or the accused, Mr. Ntanzi, was arrested on the 16th of June 2020 and brought to you on the 24th of June 22. I'm talking about 8 days from the date of arrest. Do you know that?
Ek het dit ook opgemerk.
I also noted it or marked it as such. Nami-ke ngaqaphela-ke ngaleyo ndlela-ke ukuthi kwakusemuva kwamalanga awu-8 aboshwa-ke nkathi elethwa phambi kwami.
And when he was brought to you, that's my instruction. When he was brought to you to take a confession, he was not taken to court. He never appeared in court within 48 hours.
Ek raak geen kennis of hy verskyn het of nie. Dit is nie binne my kennisveld gewees op daai stadium nie.
I have no knowledge as to whether he did go to court or not. It was not within my knowledge at that particular time. Ukuthi wayeyileke enkantolo noma akayanga-ke phambi kwemantshi angikwazi-ke lokho, akusiyona into engangiyazi ngaleso sikhathi leso.
In the normal course, when you are presiding as a magistrate, when an accused is brought after 48 hours, what normally happens in court for the benefit of the public? If a person is brought after 48 hours has lapsed, what normally happens? What is your decision as a magistrate?
Normaalweg persoonlik as landros in 'n strafhof hou ek as artikel 342A ondersoek en verwyder die saak van die rol as die omstandighede dit noodsaak.
342A. Under normal circumstances, and I would then hold a section 342A inquiry, and if need be, I would then strike the case from the court roll. Uma ke kuyisidingo noma uma umuntu eletha ke phambi kwenkantolo emuva kwamahora awu-48, ngizothi ke ngenzeke noma ngifiseke ukuthi ngazi noma ke ngenze lokho akubiza ngokuthi inquiry ke yakhe section 342A, uma kunesidingo ke lelo cala lelo ke ngilususeke kuhla lwamacala enkantolo.
Thank you. My instruction is that Mr. Ntanzi was taken to court. First appearance of Mr. Ntanzi was on the 27th of October 2020.
Ek dra geen kennis daarvan nie.
I have no knowledge of that. Ukuthi ke waqala ukuya ngqa enkantolo ngezi 27 October 2020 angikwazi lokho.
The question, as per the previous question, as per the previous answer you gave, if Mr. Ntanzi was brought before you as a magistrate on the 27th of October, if he was arrested on the 16th of June, you would strike the matter of the roll. Is that correct?
Ek sal eers 'n ondersoek doen in terme van artikel 342A, aangesien ek geen sake kan verwyder van die rol sonder sodanige ondersoek nie.
I would first have held the inquiry, the section 342A inquiry, I cannot just remove a case or strike a case off the roll without such an inquiry. Uma kuwukuthi ke wayevela phambi kwami ngazo lezo 27 zika October 2020 kube ke yena ke waboshwa ziwu-16 June 2020 bengeke nje ngibese iqala ngilisuleke kodwa bengizoqala ngifuna ukwazi ukuthi kwakungani.
From the version of the accused to say his first appearance was on the 27th of October 2020 and he was arrested on the 16th. According to this version, it was not a reasonable time for him to be brought to court. Do you agree?
Ek het nie al die feite.
Yes, my lord. I think it's wrong for my learned friend to put a question that is not correct to the witness. He's in possession of proceedings in other cases, and unless he specifies his question, that question that is put into the witness is not correct.
For clarity, I'm referring to this specific case. I'm referring to this matter.
Advokaat, ek kan net gaan op die woord van u kliënt toe hy gesê het hy is op die 16de gearresteer.
Advocate, I can only take or go based on your client's word or what the client told me that he was arrested on the 16th of June 2020. Mina ke ngingathatha nje kuphela lokho engakutshelwa ke ulo omele ukuthi waboshwa nge-16th ka June 2020.
Ek kan nie sê of hy op hierdie saak gearresteer was of op 'n ander saak nie. Ek weet nie wanneer hy verskyn het op wat nie en ek weet ook nie wanneer hy verskyn het op hierdie saak nie.
And I cannot tell as to whether he was arrested on that date on this particular matter or on another matter, and I cannot say when he did not appear or to which matter.
I'll leave that for argument, ma'am. Let's just proceed on something else. May I proceed to ask the following question? This is the pro forma. This is the statement. These are attachments. I'm referring to the copies of the IDs of the officers. Does that all this constitute a confession?
Die verklaring ten opsigte van die konfessie self is aangeheg met die voorvereistes om te kom tot daai verklaring is ook aangeheg.
Okay. The statement is also the statement is attached together with the requirements to get to that particular statement. Istatement lesi kanye nalokho okufunekayo noma okudingekayo ukuthi uyofika kusona ke statement kuhlanganisiwe.
Die verklaring sluit met ander woorde my bevinding in na aanleiding van die vrae wat gevra is, die antwoorde wat gegee is.
Now that then includes, that is now my finding with regards to the questions that I posed as well as the answers that were given. Lokho kokufaka phakathi ke imibuzo engayibuza kanye futhi neimpendulo engayithola nesinqumo engafinyelela kusona.
My question will be,
dit vorm saam 'n deel van die verklaring in terme van artikel 217.
It then forms part of the statement in terms of section 217. Kube kusuba yingxenye ke yasoke istatement lesi ke statement esenzwe phansi kwakhe ke usection 217.
Maar die bekentenis self ten opsigte van wat die deposant vir my gesê het ten opsigte van die misdaad is net ten opsigte van aanhangsel A.
But then the statement with regards to what it is that the deponent informed me with regards to the commission of the offense itself is then annexure A. Kuse kuthi ke sona ke statement lesi la khona ke engichazela kona ke ukuthi yini impela eyenzeka mayela ke necala leli bona ke bese kuba annexure A.
Die bekentenis self is dis annexure A, maar die hele dokument sluit die verrigtinge in totaliteit in.
The confession itself is Annexure A, but the entire document contains the proceedings as a whole. Bese kuthi yona ke i-confession lena noma i-statement lesawasenza ke kuba Annexure A, kodwa ke uma usuwahlanganisa ewonke ke kufaka konke okwenzeka ngaleli langa.
Okay. So I just want clarity. Annexure A consists of 6 pages, 1 to 6. Is that so?
That's correct.
That is correct. Annexure A ke ama-page awu-6, 1 yofika ku-6.
From that statement, that is the statement of the confessor or the deponent. Is that correct?
That's correct.
That is correct. Futhi lesa statement ke statement esalona ke owayekhuluma kumina engitshela.
For the benefit of the public, was it supposed to be commissioned, signed, and commissioned before a commissioner of oath?
Nee.
No. Kwangafaneleke ukuthi sibe sasayindwa ke sisiwe ke kumuntu obizwa ngokuthi commissioner ke ozobeka ke istem.
Was the statement signed?
Yeah.
Yes, yebo statement esasayindwa.
All right. May I approach my colleague?
Yes, yes.
My lord. Are you in possession of the statement?
Yeah.
That's correct.
That is correct.
Can we go to the last page? I think page 6 of the statement. Page 6 of the statement. Are you there?
That's correct.
That is correct.
You see the signature of the deponent.
Hy het hier sy initial gemaak. Die volle handtekening verskyn op bladsy 8. Nadat die verrigtinge voltooi is, het ek hom versoek om die volle handtekening te maak op die laaste bladsy wat bladsy 8 was van hierdie en dan het ons almal geteken.
It's only his initials that appear there, but his full signature is on page 8. That's when everything was now completed, when I requested him to sign, and we all signed. Ukuthi ke asayindeke akasayindanga lapha kule page 6 wabeka njena ke ama initials akhe kwase kuthi ke upage 8 page lokugcina ke ila khona ke singamcela ukuthi asayinde uma seqedwe konke nathi ke sase siyasayinda.
Right. From page 1, if I may ask you to peruse it. Peruse from page 1 up to page 5. Do you see any signature of the deponent?
Nee, net sy paraat.
No, it's only his initials. Akasayindanga ku page 1 yofika ku page 5 ukuthi nje ubeka nje ama initials akhe.
My instruction is that he has never or did not attach any initials, and he did not sign any statement, especially in front of you.
Dis 'n informal.
That is a lie. Amanga nje lawo ukuthi nje akakazi asayindeke phambi kwami noma ke abekeke ama initials akhe.
Sorry, I'm not interfering with your interpretation. So you said that is infamilian.
That's correct.
Can you just say it in English?
Infamil.
It's an absolute lie.
The notorious lie.
You said he signed on page 8.
That's correct.
That is correct.
Page 8 is a pro forma.
That's correct.
That is correct.
It's not a statement.
That's correct.
That is correct. Kuqiniswa ukuthi ngithe usayine ku page 8 nokuthi ke kuyi performer ke akusona i-statement.
A statement is separate from a pro forma. A pro forma is to insulate an inquiry before making a statement. Is that so?
U kan dit seker so interpreteer.
Maybe you can interpret it as such. Kambeke ungabeka kanjalo ukuthi iform lena ke yona ke ihlukile kusona istatement
Jy moet net onthou dat wanneer ons die bekentenis afneem, die proses in een loop.
You just have to remember that when you take down a confession that this process is a continuous process.
So ons hanteer of ek het die formaliteitsvereistes eerstes hanteer en toe hy die verklaring wou aflê, het ek dit gedoen en ek het agterna het ons hierdie dokumente onderteken nadat hy bevestig het dat alles korrek is. Ten opsigte van sy verklaring.
I first started with the requirements or with the formalities that is now on the front pages, and then when he wanted to make the statement, I then proceeded with that, and then that is when now the documents had now to be signed.
May I just hand over to you a pro forma that has a statement which has also made with the same intentions of taking a confession. This is just a confession which was taken by somebody else, which I just want to show you that there is a difference between that statement and the statement that I'm going to hand it over to you. With the leave of the court, may I hand it over to her? Yes. For comparison, my lord.
Mr. Baloyi.
This is a pro forma used by Commission to Office Justice of the Peace. I don't know whether one can really compare the two.
No, wait. You say it's a pro forma?
Of a statement taken down by Justice of the Peace. Not a magistrate.
Not a magistrate.
Yes.
Okay, fine.
So we're not comparing apples with apples.
My lord, actually the main thing is I'm not going to the pro forma per se, to the statement in which the signature of the deponent appears in the statement. Do you see that?
Ek neem kennis.
I take note.
So the statement, you see that there's a pro forma and a statement.
Ek sien dit.
I see that. Yabona ke ukuthi kune form ke yokubiza ukuthi pro forma kanye ne statement.
In that statement, there is a thumbprint from each and every page. Do you confirm that? If not all pages, but there's a thumbprint in that statement.
Ek is besig om te kyk as jy maar net die geleentheid sal gun.
Just give me an opportunity. I'm busy checking.
Ek sien die duimafdruk.
I see the thumbprint. Ngasibona ke isithupha lesi esibekiwe.
Do you see the initials at the bottom of the first page of the statement?
Ek sien daar's 'n geskribbel.
I see that it's scribbled there. Yabona kukhona nje kubhaliwe lapha yana.
Daar lyk soos 'n handtekening langs die duimafdruk en dan lyk daar soos 'n of dit 'n O of 'n Q of 'n X is en dan nog so 'n skribbel. So ek kan nie sê of dit 'n handtekening of 'n initial is nie.
I see
of
that
dit net 'n maak is nie.
I see that there's something that looks or appears like a signature next to the thumbprint, and then there's something that looks like an O, a Q, or an X, and then there's another scribble. I cannot confirm as to whether that's a signature.
Now let's go to the last page of that statement. What do you see there? Last page.
Wat is deel?
Which part?
Wat se deel verwys u nou na?
Which part are you referring to?
The last page of the statement.
Van die konfessie.
Yeah.
Ja,
What do you see there?
dieselfde geskribbel.
The same scribble ngibona nje lo mbhalo ofanayo.
En bo dit verskyn signature of justice of peace.
And then on top of that it appears a signature.
Ekskuus. Onder die geskribbels
Okay.
verskyn dit a signature of justice of the peace in die volle name.
Just underneath that scribbling then appears the signature of justice of the peace as well as the full names. Amagama ke alowo ke ukuthiwa uyena ke wayithatha amagama akhe aphelele.
En heel onderaan is daar weer 'n duimafdruk.
And once again right at the bottom there's another thumbprint. Phinde ke ezantsi kube nesithupha
Met 'n ander handtekening.
with another signature.
So there, do you see the signature of the deponent? On the same page.
Nee, want dis net 'n duimafdruk. So ek twyfel sterk dat iemand van die justice of the peace of sy kantoor het met 'n duimafdruk gaan teken. So ek kan nie vir u sê wie se handtekening is wie se nie.
Okay,
no, it's
Of
only,
wie se merk is wie se of wie se duimafdruk is hierson.
it's only a thumbprint, and I doubt strongly that a justice of the peace would then just put a thumbprint. So I cannot confirm which signature belong to who here from that which appears here. Ngibona nje isithupha lana futhi ke ngiyangabaza ukuthi ke umuntu okuyena ke owayethatha le statement kungawuyena ke ongabeka isithupha. Ngeke ngisho ukuthi le signature ngibona la ukuthi ekabani.
May I rephrase it? May I rephrase my question? The signature that appears on behalf of the words justice of peace. Other than that signature, is there any signature on that page that you see?
Daar is 'n handtekening net oor die thumbprint.
There is
Duimafdruk. Of ek weet nie wat se vinger hier af vingerafdruk is nie. Duim, voorvinger, middelvinger, ek weet nie.
there's a signature that just above the thumbprint. I cannot say it's the thumbprint, it's the middle finger, or which finger it is, but there is a signature above that.
Normaalweg behoort daar geskryf te wees wat se vingerafdruk daar gevat is.
Normally, it should be indicated there as to which particular finger was taken. Fanele ngenjwayelo ke kuvamise ukuthi ke kubhalwe ke ukuthi imuphi umunwe loyana obekiwe lapha.
Ek vind dit ook onwaarskynlik dat 'n getuie 'n thumbprint sal gee. So ek weet nie of die handtekening by hierdie vingerafdruk dien as 'n getuie tot wie se vingerafdruk gevat is of nie.
I also find it that for me it would be improbable that a witness would put his thumbprint, and now there is a signature next to that thumbprint. I don't know whether that is now to witness as to whose finger that is printed on there. Nokuthi futhi ke ufakazi angathi abesebeka isithupha sakhe ke naloko ke kuyinto engingabazisayo, nokuthi futhi kube sekuyasayindwa ke eduze kwaleso sithupha leso ngazi nokuthi lo muntu uyasho noma uchaza ukuthi umunwe kabani lo ya.
So ek vra my met alle respek om op hierdie stadium te spekuleer op wie se vingerafdruk is hier en wie se handtekening is hier. Ek neem aan die handtekening wat lyk soos 'n Q en 'n X en daar geskribbel is die Justice of the Peace. Dit is die vrederegter se handtekening bloot op feit dat op die laaste bladsy daai selfde handtekening bo die lyntjie verskyn waaronder getik is Justice of the Peace signature.
And with all due respect, now you are asking me to speculate with regard to this, and but where there's that scribble, I just assume that one would be now a signature belonging to the Justice of the Peace, because if you look at the last page, just above where it's written signature of Justice of the Peace, that signature is above that. Lana ke umcela nje noma uthi kumina ke angicabangele nje noma ngiqageleke ukuthi ubani obesayinda la ubani obebeka isithupha, kodwa ke la kungathi khona ke kunaleyo mbhalo ongathi u-O u-Q noma u-X, ngicabanga ukuthi yilona ke owayethatha istatement lesi.
So ma'am, the purpose of this exercise, the reason for giving you that statement is to compare your statement and the statement that is in front of you. That's different. Totally different.
Meneer, met alle respek, ek weet nie wat u wil vergelyk en hoe sê u dit is verskillend nie. Hierso het 'n persoon die verklaring onderteken met 'n duimafdruk.
Sorry. I don't know what it is that you find to be different and what it is that you want to compare. Because here a person made a statement and confirmed that with a thumbprint.
In my verklaring is dit bevestig deur die deposant by wyse van 'n initial.
And in my statement, it was then confirmed by the deponent by means of initialing.
So die deposante in hierdie geval het verskillende maniere gebruik om die verklaring te onderteken, of dit nou 'n merk is, 'n handtekening is of 'n duimafdruk is.
Now in these two different statements, the deponents made use of different means to confirm their statements, whether it's by a mark, by a signature, or by a thumbprint.
Ma'am, sorry, please, can I afford me to ask a question? This is your statement. This is the statement that was made in front of you. This one.
Dis korrek.
Dat is
Dit is
korrek.
bladsy 15. Dit is met ander woorde 6 van 6 heel onder. Jy sal sien heel bo by my dokumente het ek dit basies so gemerk.
You just see right at the top in my documents. That's how I marked them. That is now that would be page 6.
Yes,
page 6.
Bladsy 6 of 6.
That's correct.
6 of 6.
That's why I'm saying there's no signature of the deponent. Do
Nee,
you
maar daar's
agree?
nog steeds 'n initial hier. So of hy nou sy thumbprint daar gesit het, vol geteken het, 'n kruisie gemaak het, sy neusafdruk gesit het, hy het dit onderteken.
But now there is an initial here. Whether he initialed, he put a cross, a thumbprint, or his nose print, but he did put something there. Lana ke ukuthi ke akasayindile, kodwa ke ubekile ke ama initials wakhe, noma ke bekuyikhala libekile, noma isithupha sibekile, noma wenze I cross.
I'm not talking about the initials. I'm talking about the signature. What is important is to inform the court that the statement was never signed. There's no signature of the deponent here. In page 6.
Nee, daar's nie 'n wetlike vereiste dat hy sy volle handtekening moet gee op hierdie stadium daar nie. Hierso is en ek weet nie eens wie dit gedoen het nie. U wys vir my 'n bekentenis. Ek weet nie wie se bekentenis dit is nie. U wys vir my 'n bekentenis vrede regter met 'n duimafdruk. U is tevrede met daai duimafdruk. Maar u het 'n beswaar omdat 'n persoon nie in hierdie konfessie of bekentenis van my 'n volle handtekening gemaak het nie.
Yes, you are showing to me, firstly, there is no legal requirement for a person to do that. You are showing me here a statement where a person has put down a thumbprint and you are satisfied with that. On my side, a person initialed and you are not satisfied with that. But you are satisfied with the thumbprint.
Mits ek u verkeerd verstaan as jy dit net kan duidelik stel.
Maybe I misunderstood you. If you can just put it correctly or much clearer.
Can you interpret it, Mr.?
Which part now?
All right, may I rephrase the questions? Let's just rephrase the question. My question, very simple. At the end of the statement, page 6, last page of the statement that you have taken, other than the alleged initials, there is no signature of the deponent. That's what I'm asking.
Daar is nie 'n volle handtekening van die deposant nie. U is 100% reg.
You are 100% correct. There is no signature of the full signature of the deponent. Uqinisile ukuthi ku page 6 kulesi sami statement ayikho ka noma akasayindile ngokugcwele.
May I have that statement, please? Thank you very much on that exercise.
Are you not handing out that document?
Sorry.
Are you not handing out that document?
No, man.
What's the value then of that if the court can't even see it?
Somebody's coming to testify on that statement.
That's not the point. This is the witness who's being cross-examined on the two documents, that document, and I'm saying, are you not handing it up? That's all I want.
I'm sorry, my lord, the time annexures were handed to the court, it's one of the annexures. Just want to confirm because I was not present at that time. It's marked the, what? It's marked.
Okay.
H, my lord.
H.
H. So it's just a pro forma, my lord, I beg your pardon, because the statement is part of the redacted parts. So may I reserve that for my argument in the event a statement...
Reserve handing up the document.
It's just that your lordship will not have sight of the statement at the moment. But if the court is inclined to look just at the back of just for the purpose of the exercise, to compare the last page of the statement attached under HH and the statement attached under JJ. Only the last part of the statement, not on the contents of the...
I see a colleague here smiling. Mr. Louis.
We are of the view that the entire document must be handed up. No. Rather, let me withdraw that question.
And the document. Because
and
the handing up of the document, sorry.
And
the handing up of the document is predicated in support of your cross-examination of this witness, where you said he must compare, she must compare the two documents, that is Exhibit JJ, and as she explained it, and the facsimile, which you say she must compare her confession together with the attachments or annexures to that very facsimile which you have handed over to her.
My lord, the issue is that a statement cannot, as per agreement.
Okay. With whom?
Between the parties.
Oh, the state?
Yes, that it cannot be handed over prior to the ruling in terms of...
No, I'm aware of that.
Yes.
But that's that statement, the one which you say belongs to some other person.
Yes.
Why can't this court have sight of it? Because you are using it for comparative reasons, are you not?
I am, my lord.
Yes, I'm aware. So you are saying you are withdrawing the question now?
Because when I'm consulting with my colleagues here, I was not part of what was discussed. But if they discourage me to hand over the last page, because I indicated that only the last page for the sake of comparison, because it consists of certain parts of the statement. So that is the fear that my colleagues have for the court to have sight of.
Yeah, this is the danger you undergo when you use a document which can only be disclosed to viewing after the court has, if it has, or if it does rule that that statement was made freely and voluntary, etc. You are the one who opens the can of worms.
No, it's fine.
And yet you, all of you, you refuse me to listen to an audio recording.
It's not.
Now you want me to view a statement. The statement.
My lord is the law. It's not us. May I withdraw this?
No, it's your choice.
May I would like to withdraw it, but that will be subject of my argument. May I withdraw the last part of my question in relation to the...
So the last part of your question is withdrawn?
On page 6 of the accused statement.
Okay.
But I'm happy that the witness has confirmed that there's no signature of the deponent.
But if you say you've withdrawn that last part of the question, then her answer also.
And the answer, not the
consequential,
answer.
you're saying you're withdrawing it.
The comparison.
You're actually saying the court should not take that answer, which was elicited by your last question, by this witness.
May
You're
I
saying
clarify,
basically that.
May I clarify this?
Okay.
I'm withdrawing the comparison of both statements, but I'm not withdrawing the question that there is no signature of the deponent on the statement she has made. That's what I'm withdrawing, the comparison of the statements, but not the answer she has already tendered before this court.
And you're saying you're not going to hand up that document?
The document will be handed over at a later stage.
Mr. Barry, what's your reaction?
Well, I suppose my colleague is in charge. If he withdraws the comparison, then it means his questions and answers are now of the record, pro non-scripto basically.
Yes, Mr. Mgomezulu.
All right. Ma'am, let me have that statement that I gave you, the last statement that I gave you, so that I can safely put it on record, that in that statement that we have, that you took from the deponent, there's no signature. That's the last question on the aspect of the signature. There's no signature. Can you confirm that there's no signature? It's only the initials.
Dit is net die initials soos wat u sê op die laaste bladsy en op elke bladsy soos wat dit verkeer tot en met daai waar hy sê dat the statement is now signed by the deponent by means of his signature, is his signature ten volle aangeteken.
Yes, there is no signature from that page, as you say, as well as the other pages, up until the page that the witness is now referring to, page 8. Ne? Is where it says now his signature is now on. Yebo kuyiqiniswa ke ukuthi kuphela ke initial ayibekile lapha akuna signature ku page yokugcina ke statement uqhubeka ke kodwa kuze kuyofika ke ku page 8 la khona ke asesayine khona.
Sorry, you prefaced your answer by reading the notation. I said you understand, is blood says that's nie
Agbare, soos wat die verrigtinge plaasgevind het voor my, het al die verrigtinge eers plaasgevind. Dit sluit in die voorvereistes en toe die eedsverklaring. Waarna hy gevra is om dan sy volle handtekening te bring en elke bladsy te initial. Hierdie bladsy 8 het ek aanvanklik op hierdie verklaring wat ek oorhandig het heel agtergehaal.
Right.
Dit is lyk my teruggeskuif na sy oorspronklike plek toe. So selfs die sertifikaat van die tolk was heel agtergesit.
Right.
So ja, ten opsigte van bladsy 1, 2, 3, 4, 5 en 6 van die verklaring self van die voorval, van die beweerde voorval, is daar net initials.
That's it. Yeah.
Nie 'n volle handtekening nie.
And then on page 8.
En dan die ander ook net initials en dan die laaste bladsy wat ek beskou na aanleiding van die verrigtinge afgeloop het, 'n volle handtekening.
The last bladsy according to your
volgens die verrigtinge wat plaasgevind het voor my.
What is the last page according to
bladsy 8. Volgens die dokumente soos wat dit op die proformas gemerk is.
Bladsy 8.
Page 8 is
and you say there's a signature.
Dis 'n volle handtekening.
Which is preceded by what? Can you understand me? Did he sign because it says, having made the statement, that's what I understood you. Just put it on record, ma'am.
Dis korrek. Ek het na die tyd, toe alles afgeneem is gesê, teken volle handtekening. Hy het dit geteken, die volle handtekening, en ek het vir hom ook gevra om elke bladsy te initial wat hy ook gedoen het.
After the completion of the proceedings, I then requested him to sign, which he did, and then requested him to initial each page, which he also did.
Okay.
So in page 8, I think it's referring to page 8 of the pro forma.
Now, that's not of the statement.
The statement consists of 6 pages.
6 pages, yeah, okay.
The pro forma consists of 9 pages, or 8 pages, or if not 9.
Ja. Advokaat, die proses soos wat dit afgeloop het voor my, was nie dat daar gevra is teken enige iets.
Advocate, the process as it unfolded before me, it was not to such to the extent that you were just asked sign each and everything, yeah?
Daar was met ander woorde nie gehandel met die voorvereistes en toestehandtekeninge aangebring nie.
For an example, it was not the prerequisites that were dealt with and then thereafter asking for signatures. Indlela ke okwenzeka ngayo kwakusiwe ukuthi uqala achazelweke ukuthi iform ihamba kanjani bese kuyacelwa ukuthi asayine, yeah.
Die voorvereistes is hanteer. Daarna het ons oorgegaan op die konfessie.
Okay, the prerequisites were handled or dealt with. Thereafter, we moved to the confession. Siqaleke ngaloku okhona kwiform la ngaphambili sase siyandlulela kusona istatement.
En nadat die konfessie gemaak is het hy sy volle handtekening aangebring. Dit is die handtekening op bladsy 8 en het hy elke bladsy geparafeer.
Now, after the completion of the confession, he was then requested to sign. That is now the signature which he brought on page 8. Thereafter, requested to initial each page. Celiweke uma sengabe seqediwe ukubhala sona istatement ukuthi assigned ila assigned khona ke ku page 8 basecelwa ukuthi abeka ama initials kwi page nganye.
May I just put this version? The signature that appears on page 8 is in dispute.
Ek neem kennis.
I take note. Ngiyakuzwa ke uma uthi ke uyayiphikisa ke le signature elapha ku page 8.
The accused left that office without appending a signature to any of the documents that were in front of him.
Ek gaan 'n retoriese vraag vra. Wie sou dan namens hom geteken het? Want ek sê vir u nou, hierdie man het geteken voor my, voor sy prokureur en voor die tolk.
Okay, I'm going to ask you a rhetorical question. Who would have then now signed in his space or in his place? Because this gentleman signed in the presence of his legal representative, in the presence of the interpreter. Uma kuukuthi uthike wahamba lapho engasayindanga, ubani kwasayinde endaweni yakhe, ngoba usayinde ummeli wakhe khona, utolika ekhona.
Die tolk sowel as hierdie prokureur kan daaroor getuig as u my woord in twyfel trek.
The interpreter as well as this legal representative can now attest to that if it is now that you are disputing that which I am saying.
Dat die bandopname wat die prosedure volledig uiteensit nie toegelaat is vir redes op rekord nie.
Taking into account that the recording which now recorded the proceedings was not admitted in court or as part of evidence. Lana ke uma kuukuthi ke lokho engikushoyo mina ke uyangabaza noma ke awukuthathi ke utolika nalo mmeli lo owayekhona usebengabizwa ke bazoqinisekisa ke lokhu mina ke engikushoyo.
Okay, may I just put this version? Before I just, can you please read before the alleged signature? There's a sentence on page 8.
Is that part of the statement?
The pro forma, my lord, sorry.
Oh, it's not that part of the statement.
The pro forma.
The pro forma, okay.
On page 8.
Yeah, because I'm entitled legally to have sight of the pro forma.
Thank you, my lord.
The statement is now signed by the department by means of his signature.
Statement ke manje siyasayindwa ke lona ke bewenza istatement ngokuthi asayinde.
Hierdie bladsy is geteken na alles afgeloop is.
This page was signed after everything had been done. Die page
Toe het hy volledig geteken, die tolk het volledig geteken en ek het volledig geteken en die tyd van completion van hierdie hele verrigting was 20 minute oor 5 die middag.
He signed in full, the interpreter signed in full, I then signed, and then the time of completion of these entire proceedings was 5:20. Lana-ke uyena-ke owasayinda-ke futhi ke i-document lena isayindwe emuva kokuthi konke sekwenziwe seqediwe-ke.
So hierdie handtekeninge is nie afgeneem na completion van die verrigtinge van die proforma vorm nie. Dit is gedoen nadat die proforma vorm voltooi is tot in bladsy 7 en die konfessie afgeneem is en hy gevra is toe om te teken.
Now this signature, which appears on page 8, was not appended after the completion of the proforma. It was after the proforma was done up to page, you said page 7, yes, and then the confession was taken down, and then it was only then after it had been completed when he now appended his signature on page 8. Ukusayinda-ke kwakhe la ku page 8 akwenzekanga ngemuva kokuthi sesiqede isigaba sokuqala seform lokho kubizwa ukuthi i-proforma iqediwe leyo sangena kwistatimende emuva kwalokho-ke yila khona-ke asesayina khona.
All right. The signature of the attorney who was present, was it not necessary to be appended?
Ek het dit nie nodig geag dat die prokureur ook moes teken nie.
I didn't see the need or see it necessary for the lawyer to also sign. Angizange kuboneke kuyisidingo ukuthi umeli naye asayine.
But if he signed, it was going to be much easier to see that he was present on that day. Do you agree?
Meneer, ek het
Sorry, ma'am. If he signed, if the attorney, as you say, he was present on that day, if he signed, that's just a general question.
Meneer,
If he
met alle
signed,
respek, al het hierdie man geteken, sou u nog steeds in lig van die omstandighede dit ontken het. Ek het hier opgeteken dat hierdie man teenwoordig was, meneer Njiako, en u glo dit nie. Ek glo nie dat enige handtekening eers 'n verskil sou maak nie.
Even if he had signed, you would still, under the circumstances, you would still have disputed it, because I wrote here Mr. Dominic Njiako, but still you are still not taking my word. So I don't see that any signature would have made a difference.
Sy Fidelity Fund sertifikaatnommer is hier neergeskryf en nog steeds aanvaar u dit nie, want dit is u opdrag. Ek respekteer die opdrag, maar die feit bly staan. As u wil voorgee dat enige verdere handtekeninge 'n verskil sou maak, dan is die antwoord nee, want u en die kliënt sou dit nie aanvaar het nie.
I respect the fact that it is your instruction, but I am saying to you that any other signature would have made a difference here, because you and your clients would not have accepted that. Ukuthi ke umjiyako ngabe usayindile lana angiboni ukuthi bekuzokwenza umehluko lokho, ngoba ke nansi ke nenamba yakhe ke ye Fidelity Funds ibhaliwe lapha, kodwa ke naloko awukwamukeli ukuthi nokuthi ke yiloko okutshelwa umsola. Ngiyakuhlonipha ke, kodwa ngiboni ukuthi nje isignature enye ibizokwenza umehluko kule document.
may I just put my version, the version of the accused? Because I can see that nothing on this pro forma that has been attached, that one may conclude that an attorney was present at the time of the. But let me just put the version of the accused. When he was brought to you, before he was brought to you, I know you were not present. It's going to be it's not going to be a fair question, because you were not present at that time when the alleged torture was occurred or was conducted on the accused. But my instruction before you descend on that box is to tell you that he was subjected to a severe assault, severe torture in 4 different places before he was brought to you to make such a confession. Can you comment on that?
Ja, advokaat, hierdie man het op verskeie kere op verskeie wyse vir my te kenne gegee dat hy nie aangerand was nie.
I advocate this gentleman made it known to me on several occasions, in several ways, that he was not assaulted. Lo mlisa-ke wangitshela-ke amahlandla-ke nangey'ndlela-ke ithizeke ukuthi akakaze ashaywe.
Geen beserings is moet ek net klaar praat. Geen beserings is genotuleer nie, waargeneem deur my nie. Toe ek hom gevra het hy enige beserings, kan hy dit uitwys? Is geen beserings deur hom aan my uitgewys. Behalwe ou merke wat reeds gesond geword het ten opsigte van voorval wat hy opgedoen het met sy ouma toe hy 'n kind was.
No injuries were shown or pointed out to me or were visible to me. Even when I had asked him about those or such injuries, he referred me or mentioned to me old wounds or injuries that occurred or was as a result of an incident between himself and his grandmother when he was still very young. Akukho ukulimala awangibonisa kona noma awakusho kumina futhi ke nokulimala angitshengisa kona noma akhuluma ngako ila athi walimala khona esemncane kakhulu kwisehlakalo esasihlanganisa yena ke nogogo wakhe.
Daar was geen rede hoekom hy dit nie vir my kon rapporteer nie. Daar was geen rede as hy nog beserings gehad het wat veroorsaak was deur aanranding deur die polisie of deur enige iemand aan my kon uitwys nie.
There was no reason that he preferred to me or that he should not have appointed or shown me or told me about those injuries or injuries that he had at the stage or that were caused by police on him. Sasingekho ke nesizathu esasingambangela noma esasimbangela ukuthi angangitshengisi noma angangitsheli ke ngokulimala owayenako okwabangelwa ke noma amaphoyisa.
En in lig daarvan dat u sê hy op 3 of 4 geleenthede soos wat u dit noem en ek wil aan severely assaulted was, vind ek dit baie vreemd dat hy dit nie vir my sou noem ten minste nie.
I find it very strange what you just mentioned now that as you said that on 3 or 4 different occasions that he would at least not have mentioned it to me. Kuyangimangaza-ke ukuthi nanjengoba usho ukuthi lo mlisa-ke washaywa-ke amahlandla ahlukile amathathu noma amahlandla amane ukuthi nje akakaze nje angitshele ngalokho.
All right. And you'll agree with me that you can dispute that, is fine. I'm just putting the version of the accused. Whether you believe it or not, it's fine. But what would be your take? You are handcuffed, and as per your words in that pro forma, you said the police were heavily armed. Psychologically, did not that have manipulated his mental ability? I know you are not a doctor, but psychologically, on the observation, here are the police heavily armed.
Meneer, ek gaan nie so antwoord. Is reg, ek is nie 'n mediese praktisyn of 'n sielkundige om te weet wat die sielkundige uitwerking het op 'n persoon wat daar staan met boeye aan nie. Maar hierdie man het glad nie voorgekom as iemand wat vreesagtig is.
Sir, you are right that I am not a medical practitioner, and I also don't know as to what the psychological effect thereof would be. But this gentleman, as he was there, he didn't appear as someone who was fearful.
Hy het kalm voorgekom.
He appeared calm.
Hy was baie rustig geweest, hy het baie rustig gepraat met my.
He was very relaxed and he was even relaxed when he spoke to me.
Hy was begeerig om te praat.
He really wanted to talk.
Hy het selfs die boeye aan sy hande was los. Dit het geklink soos 'n vrou wat los bangles dra. Dit was los om sy gewrigte.
Even the handcuffs were loose. They sounded like a lady who was having bangles around because they were loose in his arms.
Toe ek met hom gepraat het en vir hom gevra hoe gaan dit? In die begin toe hy daar in die kantoor ingekom het hy my ek het hom gegroet, hy het my teruggegroet. Ek het hom gevra hoe gaan dit? Hy het vir my gesê dit gaan baie goed, dankie. Hy het intedeel vir my teruggevra hoe gaan dit met my? En ek het gesê, goed,
Yes.
so hierdie man het nie voorgekom. Soos enige persoon wat vreesagtig was, bang was, beangs was, aangerand was, niks nie.
And as I entered there, I greeted him. I asked him how he was. He responded to me, and he even asked me back as to how I was. And as this gentleman was there, never appeared to be someone who was fearful, someone who was anxious. Lo muntu ke noma ke umlisa lona ke kwakungasiyena ke umuntu owayesaba ebonakala noma ebukeka ke umuntu osabayo, kwakubonakala ukuthi umuntu onesifiso noma ofunayo ukuthi akhulume nabo ke ozankosi laba befakwe ezandleni zakhe ke babengaboshiwe babe loose la kena ke uze wenza isibonelelo wathi kwakuwathi umuntu wesimame ofake ama bangles a loose la kena ke ezandleni zakhe. Ngambulisa noma ke ngambingelela uma ngena ngambuza ukuthi ukahle yini, wangiphendula naye futhi wangibingelela wangibuza ukuthi ngikahle yini.
Inteendeel, die enigste antwoord wat hy vir my gegee het, het julle by ooreenkoms uitgehaal uit die vereistes uit. En dit was glad nie 'n refleksie op die polisie gewees.
And there is only
of iets wat hulle sou doen nie.
And it is only, there is one thing that he told me, but it is one of those redacted versions, one of those that you redacted, and it was never anything that pointed to the police. Sorry?
Or what they did.
Or what they did. Kunye nje kodwa ke awangitshela kona ke kodwa ke ngeshwa kuyingxenye yalokhu ke enithi ke ngiyacela ukuthi angafundwa ke noma ke nikusulileke la ku statement ke kodwa lokho kwakungasiyona nje inkomba kumaphoyisa noma lokho abakwenza.
Okay. I hear what you are saying. On all what you are saying, these police officers which you took, I think one of them you said is Lesareng, something like that. According to my instruction, is that all that was happening there, it happened in the presence of the police. I think 2 or 3 police that were there. It is Mkhano and other 2 metropolis officers. Do you dispute that?
As you see all that was happening there, kan u nie
taking the confession, completing the pro forma, not the assault.
Ekskuus, kan ek net weer duidelikheid kry oor die vraag? All that was happening there took place in the presence of the people that you quoted.
In room 2.
Is dit nou, is die bewering hulle was in die kantoor gewees toe hierdie verrigtinge plaasvind?
Is the allegation that they were in the office when these proceedings were underway?
Ekskuus, ek verstaan nie die stelling, ek wil net
The
duidelikheid.
instruction,
I just want clarity, I don't understand.
the instruction is that when you took or when you conducted this interview, it was conducted in the presence of the police, including Mr. Mkhano. My question is, do you dispute that? Because other police officers were roaming around outside the office in the passage, as per your evidence.
Ontken ek daai bewering. Die kliënt weet dat die enigste tyd wat meneer Lesareng en Jonathan in die kantoor was reg aan die begin gewees toe hulle aanstellingssertifikaat afskrifte vir my gegee het.
Okay, dankie. Advocate, I absolutely deny that instruction from your client. Your client knows very well that that is not true. The only time that Mr. Lesareng as well as Jonathan were in the office, it was right at the beginning when they came to give me their appointment certificates. Uyazi-ke nalo nomele ukuthi akulona-ke iqiniso ukuthi ngale nkathi kwenzeka konke lokhu ngithatha istatement ngikhuluma naye kwakude amaphoyisa phakathi. Kuphela kwesikhathi laphona uLesareng kanye noJonathan babephakathi kwakungesikhathi babeletheke ama-documents abo-ke la kwakufanele ukuthi ngiwahlanganise khona la.
Sergeant Mugwane het sy aanstellingssertifikaat vir my gegee en sy naam en goed vir my gegee nadat die deposant sy volle naam en van gegee het met sy identiteitsnommer waarna uit is uit die kantoor uit.
And then Sergeant Mugwane then gave me his particulars or his name and surname as well as certificate. It was after the deponent had given me his particulars, his name and surname, his date of birth, and thereafter he was out of the office.
En daarna het die kwessie ten opsigte van die prokureur ter sprake gekom. Die deposant het die prokureur uitgewys, dis sy prokureur, gesê die prokureur moet homself voorstel, prokureur het dit gedoen ensovoorts, en die verrigting het 'n aanvang geneem. Nie enige van hierdie twee persone wie se aanstellingssertifikate hier aan is, of hierdie sergeant Mogani was in daai kantoor gewees.
And then the question of the legal representative or the attorney then came up. That's when the deponent introduced or pointed out the gentleman as being his attorney, and the attorney confirmed that. And when that happened, none of these two gentlemen that you mentioned, or Jonathan and Lisering, as well as Mukhan, were in the office when that happened. Emuva kwalokho-ke kwase iy'nkathi-ke la khona-ke yena-ke umsolwa-ke esengichazela-ke noma ekhomba-ke ethi ummeli wami lona, ummeli wase uyakuvuma-ke lokho. Ngaleso sikhathi-ke akekho noyedwa kulabo babizayo-ke abo-Lisering, o-Jonathan kanye noMugane ababekhona e-ofisini.
Ek weet nie hoe hy kon sien wat buite die kantoor aangaan nie, want ek kon dit nie sien nie, want daai deur was toe gewees. Almal was reeds uit by die kantoor uit gewees.
And I don't know how it is that he saw the movements outside, because I couldn't see that, because that particular door was closed and everyone was already out. Ukuthi-ke wakubona kanjani ukuthi kwakwenzekani ngaphandle, angazi ukuthi wakubona kanjani lokho, ngoba-ke isicabha lesi sasivaliwe, mina-ke ngangingakuboni okwenzekayo ngaphandle, futhi babe sebephume bonke.
En teen daardie tyd het sergeant Mogani my reeds te kenne gegee dat die res van metro personeel wat daar teenwoordig was, geloop het in die gange weg. Hulle is weg. Hulle was nie daar gewees volgens hom nie.
And at that stage, I had already been informed by Sergeant Mogane that the members, the Metro Police members that were in the passage, that they were gone, they were no longer there anymore. Ngaleso sikhathi-ke ngase ngitsheliwe uyena uMogane ukuthi laba be-Metro Police ababekhona lapha epassageni babe sebengekho, behambile.
En teen daardie tyd, dit was toe ek vir hom gevra het, waar's die ander mense se besonderhede wat ek dit meegedeel was. So, toe sergeant Mogane uit die kantoor uit is, kon nie een van ons deur daai deur sien of deur die muur sien nie. Dit was toe gewees.
And it was now at that stage when I was then asking about the documents of the others, when he informed me about that. And after Sergeant Mogane was out of the office, that door was closed. And we couldn't see through the door or through the wall. Ngaleso sikhathi leso-ke ngitshelwa lokho, kwakuwukuthi-ke uMogane ngangimbuza ukuthi akuphi ama-documents abanye, ila engitshela khona ukuthi bahambile-ke. Uthe uMogane sephumile-ke e-ofisini, usicabha sasivaliwe, sasingeke sibone ngale kwesicabha noma ngale kodonga.
Toe hy uit die kantoor uitgegaan het, saam met sy prokureur, weet ek egter nie wat die omstandighede daar was en hoe hy daar verwyder is nie.
And when he left the office together with his attorney, I don't know what the circumstances were now there, around there, and to how he was taken away from there. Uma sephuma-ke noma esephumile ofisini kanye nommeli wakhe ukuthi wahanjiswa kanjani-ke kuso lapho angikwazi lokho.
Want toe ek uitstap was daar niemand in die gang behalwe mevrou Du Plessis nie.
Because when I walked out, there was no one in the passage except Mrs. Du Plessis. Wangekho umuntu-ke epassage uma ngiphuma mina ngaphandle kwakhe uMrs. Du Plessis.
Then you ask the deponent whether he wanted to take a bath. Do you remember saying that?
Ek het vir hom verduidelik, as u gaan na die dokument toe.
If you go to the document, I explained to him.
Na bladsy, net kyk na die regte bladsy hierso. Bladsy 1, voor bladsy.
Page 1.
Yes.
Nee, wag net, ek het net hier kyk. Sien my net 'n geleentheid sal vind.
Just to give me a moment.
Goed. Op bladsy 4.
Page 4.
van paragraaf 8.
Paragraph 8.
Yes.
Goed. Ek het vir hom daai vraag gevra en kan ek hom maar inlees of
Can I read it in that question?
Yes, please.
Goed. Ek het vir hom gevra, from the above mentioned questions and answers, it appears to me that the deponent, that's a finding that I
Sorry,
made.
ma'am, just a second. Just need to confirm if it has been redacted.
It hasn't been redacted.
No, yeah. Not the redacted. You can read it.
Ek het hom daai vraag gevra, ten minste ek het daai stelling gelees, ek het dit intedeel vir hom uitgelees. En dan is daar 'n instruksie basies 'n voorstel. Indicate whether the deponent appears to be nervous, anxious, relaxed, tearful, jovial, and or whether he has any special requests. So ek het vir hom gevra of hy enige spesiale requests het.
There is that instruction there asking about the special request. So I basically asked him if he had any special request. Mina-ke ngambuza ukuthi sikhona yini isicelo anaso.
En sover my recollection is to vra hy vir my soos wat.
And as far as I can recall, he then asked me something like, wangibuza-ke ukuthi okufana nani into enjengani. Yes.
Ek het genoem, miskien 'n bad, ek weet nie wat jou behoefte is of wat jy nodig het nie, as 'n voorbeeld.
And then I mentioned to him maybe a bath. I don't know what your need is or what it is. Just as an example, ngase ngithi kuyena-ke mhlampe nje ukugeza-ke angazi ukuthi isidingo sakho siyini.
Waarna hy gesê het, I request a bath to contact my family and have an exchange of clothes and to call my child. En die rede hoekom ek verwys het na die bad is maar omdat hy vroeër vir my gesê het dat hy van die 16de Junie af nie gebad het nie. So logika sê vir 'n mens, as jy van die 16de af sê jy het nie gebad nie en daar word vir jou gevra wat se behoeftes jy dalk het, kan dit dalk een van die behoeftes wees. Ek het hom gevra, dis nie noodwendig dat hy dit gehad het nie of moes gehad het nie en dit was die antwoord gewees wat hy gegee het.
And the reason for me asking him that, it was based on what he had told me previously, that he hadn't taken a bath since the 16th of June 2020. So now logic tells you that if someone hadn't taken a bath for such a long time. So that is basically what I had asked him. Ukuthi-ke lokho ngimbuza ukuthi kwasasiyini isidingo sakhe noma-ke ngoba wayengitshelile-ke ngaphambilini ukuthi kusuka ngesikhathi-ke engakaze ageze ngeyi-16 zikaJune. Lana-ke futhi okunye abekushilo ukuthi ngacela noma ngiyacela-ke ngicela ukuthi ngigeze ukuthi-ke ngixhumane nomndeni wami futhi-ke ngishintshe impahla lezi engiyigqokile nokuthi futhi ngishayele ucingo ingane yami.
Was that a direct communication between yourselves and the deponent, or was it interpreted through an interpreter?
Ek het dit direk aan hom gevra, die tolk het dit vertolk en hy het vir my geantwoord en die tolk het teruggetolk.
As far as I can remember, I asked him directly. The interpreter interpreted that, and then he responded, and it was interpreted back. Khumbula kahle-ke ukuthi ngabuza yena-ke uTolika wase ekhumusha-ke loko wangiphendula-ke wase futhi uphinde uTolika ekhumusha futhi.
Even the statement that was taken, was it sorry, what language was it?
Daar's aan my meegedeel dat hy Zulu praat.
It was mentioned to me that I was a Zulu speaking. Ngatshelwa ukuthi-ke ukhuluma isiZulu.
There's somewhere where you indicated that the deponent has a heart problem. Can you recall that in your pro forma?
Dis korrek, dis wat hy my meegedeel het.
That's correct, that's what he informed me. Ukuthi-ke wayinenkinga-ke inhliziyo, into angitshela yona leyo.
Did you bother to ask the nature of his illness, the extent or the condition at that time when he was before you? Whether he need medical attention or not?
Nee,
No, angizange ke ngimbuze ke noma ngene kabanzi ke ngimbuze ngalokho noma ngifisa ukwazi ke.
En die rede daarvoor, hy het nie gesê hy het nog steeds 'n hartprobleem nie. Hy het vir die hof gesê of vir my gesê hy het ene gehad. He had one, like in the past. Not have one or has one, like in the present. As hy vir my gesê dat hy nog steeds ene het, dan sou ek dit verder gevat het.
If he had indicated that he still had that problem, then I would have taken it further. Akusu ukuthi ke wayethi inkinga ke leyo anayo ke ngaleso sikhathi wayengitshela ukuthi kwakuyinto ayenayo ngaphambilini. Uma kuwukuthi wayengitshela ukuthi ke kwakusaqhubeka ke ngangizokwenza ke nangangizoqinisekisa ke ukuthi khona ke okwenzekayo noma engikwenzayo.
Okay, before I conclude my cross-examination, I just want to ascertain myself if the aspects that, okay. Sound and circumstances. May I approach accused number?
Yes.
Thank you, my Lord, for your indulgence. That concludes my cross-examination.
Okay,
God
thank you.
please.
Any re-examination? Oh, sorry, not that, yeah, not that. What's your time there?
It's almost half past, but I think we can finish with the witness.
At 3:30.
6 past.
26 past 3.
Yes.
You want us to continue?
Yes, I think we
Okay.
can finish with the witness.
Okay. Mr. Nisi, any questions?
My learned friends, I've got cross-examination. Maybe we can stand down until Monday. The witness has said she can still spare some time
Is that so?
on Monday.
Sal dit gerieflik word vir u aan maandag op dag.
Dit moet een of ander tyd gedoen word en so gou as moontlik, want of ek nou maandag kom of later kom, dit het 'n impak op my hof. Ek sal verkies dat ek dit oorkry sodat ek kan teruggaan voltyds na die kantoor.
Whether it's done anytime, my Lord, because I would have to finish it because it has an impact on my court role. So it has to be done.
Okay, ek verstaan. So we continue on Monday, Mr. Nisi. You have the whole week, Monday. Okay, Monday then.
Guys, wow. This Vivian talks too much. Vivian talks too much. That's why I didn't want it to be question. But anyway, it was good. Now, Non-Chancellor raised an interesting one. She was saying that this lady heard that this person is having a heart problem, and then she continued to do what she was doing, and she did not actually give this this man a chance. He did not even say that. He did not say it. It did not actually present that story in the beginning. Rather, it did not. She did not represent that. So you will see now that that's something that we are checking now. Gomez Zulu is actually doing a good job. He's actually doing something that is nice, and we will see with Mnisi how is he going to do his cross-examination, because we really need his cross-examination to come in. So this one is indicated that there was no signing of those papers. So in other words, they managed to rule out the issue of the audio. They are now pushing to rule out this lady's confession, this testimony of this lady. It has to be flushed out as well. So there's a lot actually that is happening there. But now we will see again on Monday how everything is going to go down on Monday, because we can't wait to see how it will unfold on Monday. So guys, thanks for connecting. Have a wonderful weekend and enjoy yourself, and I know that you will actually behave. You will behave actually. Let's see how it's going to be. So the man was prepared. He did not beat around the bush. He did not waste time. The only one that was wasting time was Vivian Cronje. She was actually going here and there, up and down, going left, right, and center, doing a lot of unnecessary things. So you can see now that it becomes a problem when somebody plays around with our time as well, because she's asked this question, she goes left. She's asked this question, she goes right. So at the end of the day, she was actually playing around with our minds. So guys, so thank you for being part of this live stream. I will see you now. I will see you. Listen to me. I'm saying I will see you now. I'll see you Monday at 10. Definitely. Let us be here at 10 on Monday. Have safe weekend. Tato. Pindile. Bakepi Wase. Pesta Bongani. Pili. Sabela France, Nonhlanhla Siabulela. Who is this one? Lulama, Kanyisile, Gloria, Tandenkosi. Actually, all of you guys, Tandeka. Actually, all of you. I can't read all these names. You have a wonderful, wonderful, wonderful week, and I know that you will actually behave. Like I said, you will behave. So enjoy your weekend. We will see again on Monday at 10. Bye.
South Africa woke this Monday to devastating news. Soccer star Senzo Meyiwa murdered.
This is a national tragedy.
Why Senzo? There was a cover up. There were so many different stories.
Help us. We want to know who killed Senzo.
For that independent, whatever paper they are, how dare you? When you go out like that and write something so false and untruth and misleading the nation.
Okay.
Because at the end of the day, I promise you this, you will have an egg on your face. I've spoken about the Senzo Meyiwa issue so many times, but people have decided that they want me guilty.
I see.
You know,
the court of public
yes,
opinion.
they have decided. So why defend myself? They must believe what they want to believe. Me and God know the truth. One thing I will never do is to protect someone who killed the father of my daughter's father. At what expense, really? So they can believe whatever they want to believe. At the end of the day, God still wins.